Welcome to True Crime and Celebrity News. If live breaking news and court trials and following true crime your thing, please consider subscribing to my channel, and if you see what you like in my content, please consider giving the content a thumbs up. Welcome to True Crime and Celebrity News. If live breaking news and court trials and following true crime your thing, please consider subscribing to my channel, and if you see what you like in my content, please consider giving the content a thumbs up. Welcome to True Crime and Celebrity News. If live breaking news and court trials and following true crime your thing, please consider subscribing to my channel, and if you see what you like in my content, please consider giving the content a thumbs up.
Good morning. It's True Crime and Celebrity News coming to you on this lovely Friday. It's really nice here in Iowa today. Today is November 14th, 2025. It's 11 o'clock. And please, if you can you like and maybe give this live a share? And if you're in the replay crew and you are watching this, can you give it a like, share, and maybe subscribe if you enjoy my content? Today, we're doing the Devyn Michaels trial. It's day 7. The state rested yesterday, so we're going to see what the defense is going to do today. I think they have a couple witnesses. I can't remember, but we'll see. We're waiting. I seen the judge's head, so we can share it. Not quite that big. Holy crap. Forgot to share the screen. I hope you all are having a good Friday. Don't forget, people from the replay, I am streaming tomorrow and Sunday. I'm going to do the trial of the Tower adoptive kid. Oh my God, it's a horrible situation what he did to his foster parents. But they adopted him from Ukraine, and yeah, I guess they were so scared of him that they locked their doors when they slept at night. So that goes to show you that things weren't very good there. I seen the judge's head popping up and down, so they should be starting. Oh wait, I'm behind. Maybe they have. Nope. I'm going to go grab some more coffee. I will be right back. We're waiting.
All rise for the jury.
Oh, I can hear them. Can't see them, but we can hear them. So yeah, I'm going to start streaming the trial tomorrow at 9 a.m. They're at
You see you're out of the jury.
verdict watch right now, so and it's only like 2.5 days.
Back on the record, C 377-399-8, Deputy District Attorney on behalf of the state, the full parties stipulated in the presence of our jury.
Yes, Your Honor.
Yes, Your Honor.
All right. The state rested their case yesterday. Defense, do you have any witnesses you intend to call?
Yes, Your Honor. We're going to call Sean O'Brien.
She's got really proper sitting, like she sits proper. Do they say Sean O'Brien?
I do. Sure. Sean O'Brien, Sean-Obrien.
Good morning, Miss. I'm sorry. Good morning, Mr. O'Brien. How are you doing?
Pretty good.
How are you employed?
So I'm employed with Roll-Off to Digital Forensics.
Okay, and what's your position there?
I am a digital forensic examiner.
Okay, can you give us a description of that job? What are your duties? What do you look at? What do you do?
Sure. As a forensic examiner, I look at any type of digital devices, digital artifacts, just pretty much anything that you can connect to the internet or even standalone, not connect to the internet, but it's digital in nature.
And about how long have you worked in this field?
Over 20 years.
Okay, you want to tell us about that, previous job assignments? Give us a little bit about yourself.
Sure. So I started off, I got a little intro to it whenever I was active duty in the Army. Got out of the Army, got recalled after 9/11. From there, moved on to the Air Force Office of Special Investigations Laboratory in Lithicum, Maryland. That's where I began my forensic journey, starting at the ground up from the basic taking a device and capturing it, as you saw earlier. From there, I got lots of training. I'm a Department of Defense certified forensic examiner. I also hold certifications with Cellbrite and Magnet and various other certifications related to the field. I worked there for about 9.5 years. I started off, like I said, it's technically called the imaging and extraction section. From there, I moved on to becoming a full-fledged examiner, and in that role, I was part of a child exploitation division that combated child exploitation and just all the different digital devices associated with that. From there, I went to the counterintelligence, counterespionage section and worked there as the deputy section chief. So I had a team of people under me that I mentored and taught how to do more advanced digital forensics. From that point, I went on like a little teaching circuit around the world to teach more stuff on like sexual exploitation type material. And then after that, I spent a little bit more time there at, it was called DCFL at the time. And then I switched over to Navy NCIS. I was offered a position to go start up a digital forensic lab, or restart a digital forensic lab in Naples, Italy. I was the sole digital forensic expert for Europe and Africa and backup for the Middle East. I covered all those countries. As part of that duty, I also worked in hand and on location with essentially like the special forces of the military police for Italy, and worked in a lot of like terrorism cases and stuff like that with them. I also worked with NATO, establishing the baseline digital forensics standard operating procedures so that everybody in NATO would have a baseline, because you have a lot of different economics, like there's very wealthy countries in Europe and there's not so wealthy countries in Europe. So trying to teach them how to do forensics with the bare minimum, because a lot of the tools are extremely expensive, and just teaching them how to balance the cost versus that. I spent 8.5 years doing that. I had to return to America, and I started working for the Veterans Affairs in the Office of Inspectors General. I ran the e-discovery division. It's essentially, it's not forensics, but it is in a related field, and I managed a team of people that would pull emails and do examinations and help agents and other requesting officers or parties to do audits and things like that. From there, I left and came over to roll off digital forensics, and here I am today.
All right, so now you work for your forensic company. What are some of the programs or software that you use in your role at your current job?
So my primary tools are some of the ones that you've seen here. Cellbrite and Magnet are probably the top two that I use.
All right, and then what about any certifications on those programs? Any training on those programs specifically?
I'm certified with both Magnet and Cellbrite to be an examiner and like to extract the devices, to get the device and get the information off of it and then process it and review it.
And so when you're not just talking about cell phone like pictures and things like that, you can also look at locations and all of those types of things as well that go into anything with the digital forensics, correct?
Correct. Cell phones are essentially databases, so it's looking at all the different databases, some that can be seen, some that can't be seen in particular readers, so you have to use different tools to get to it and look at the data inside of those databases.
So I'd like to turn your attention to this case. Myself and Mr. Drastovich called you to hop on to this case and help us to go through, I believe there's 6 terabytes of discovery on this case to go through?
There is a
lot. Like that. There's a lot. And we asked you to look at a few things. What were those?
So cell phones, the cell tower records, looked at the Barilla extraction of the infotainment center. So everything that has to do with the cell phones, the cell towers, and the vehicle.
Okay, so right now I'm gonna turn your attention to the cell phone examinations. You were tasked to look at certain things dealing with cell phones, correct?
Correct. I was primarily focused on 3 different cell phones. The cell phone of Devyn, Johnathan, and Devyn.
And did you have an opinion on the accuracy of the information that was given to you?
I mean, accuracy, it's the data that's on there. Are you asking more like, was there anything that stood out, or?
Well, was it the accuracy of the extractions? Is there anything that was missing or that you would have liked to see more?
So as previously stated, the cell phones are made up of databases, and I stated that the software doesn't always pull all the information. So the information that I was provided was a UFED reader report, which is after you do an extraction, you take that data, you put it into another piece of software, and then you can create a reader report, which is what I reviewed in this. That is only the data that is able to be interpreted by the software. So I found it problematic because over my review and looking at everything, it's only, of all of the apps that are on the phone, the average between the three devices was only 3% of the data was displayed and presented with the databases backing it up.
So would it be your opinion that this was incomplete as what was provided to you as a whole?
Yes.
And what's the basis for your opinion on it being incomplete?
Years of experience in knowing that one tool doesn't do it all, and that whenever you look at that and you see something as low as 3%, like, okay, well, what else is there? What am I missing? Personally, if I pull up Cellbrite, I'm looking through it, I don't work off of reader reports. It's a bad practice because, again, you don't have all the information. I typically use Cellbrite as an initial tool. It's very good. It's accurate. It's accepted all over the world. The data that it displays is great. The way that it displays it is great. But sometimes you're like, well, I want to know more about that. And if you're in a reader report, you can't go back to, say, a database that holds messages and be able to find out more information about those files and to look in the databases and see the different information. So not having that is problematic. And then I typically use other tools. So if there's a database I can't get into, I could run it against, throw it in.
Good morning, Cindy. Good morning, Kathy. Thank you so much for being here. Yeah, you can watch long crime. Sure. Sometimes I'll go on my phone and leave their chat up so I can kind of know what's going on. And I just wanted to remind everybody that to like, share, and subscribe. And I found somebody today to work on an intro for me. So hopefully they can get that worked on and get it to me. And don't forget, tomorrow I'm going to cover that case of the one out of Northport, Florida. The one where the adopted kid unalived his adopted parents. Oh, just a horrible, horrible situation out there. But yeah, I'm here. Thank you for being here. Let's hear what this guy has to say. He's for the defense.
The magnet axiom.
And I hear Devyn is not going to take the stand from what I was reading in their chat earlier.
And be able to pull that up and look at it in a different tool to try to verify information as well as see if there's any additional information that can be gleaned. If there's databases there that I can't get into, then I can pull it like DB browser or some other deconstructing tool that deconstructs the database so you can look at it in different manners.
And I believe it was yesterday, Detective Campbell came in for the state and testified about UFD, and I'd asked him some questions about UFDR. And could you kind of explain to the jury the difference between the terminology before we go any further?
Sure. So,
yes, Cindy, I agree. The case is very, very sad. I'm not in it for all that. I want to see that couple get the justice that they deserve. Those two deserve so much justice. What he did to them was awful. I mean, if you guys don't want to watch the bad parts, I can, we'll wait a little bit. I mean, we're ahead of them anyways. We can fast forward through some of that stuff. So if you tell me, hey, can we fast forward through this? I will. I have no problem with doing whatever that you guys want to do. You're here supporting me. I can support you also. So, all right.
whenever you get a cell phone, if it's all right, I'd actually like to start prior to that, if that's possible.
Course.
Okay, so whenever I've been to many crime scenes and was the person that collected the digital evidence and worked it all the way to trial, as you see today. The standard procedure is to get on site. What's this case? So first of all, you have to figure out what's your scope. What are you looking at? What do you have authority to look at? What type of evidence can you get? So first thing I do is I look after all the photos are taken, because that's the first thing that happens. The crime scene investigators come in, they take the pictures, and then we go in, we start doing a search. If I see anything that's digital in nature, I stop. If I don't have a camera on me, or there's another person that's assigned to take pictures, that person would come up, or I would come up, take a picture in the state that it's in the location that it's at. And then from there, once that's been categorized and like logged down, then you would take that, secure it from being connected to any networks, so turning off data, putting it in airplane mode as a bare minimum. From there, you would then, if you're not processing it on scene, you would put it in a bag, seal it, evidence tape, do all that, take it back to the lab, take it out, and then begin your extraction. So that, we're going to use a phone for this example. The phone that was collected, I would connect that to what's it's called UFED, and there is a UFED for PC, which is software that's on a laptop, and you can connect the phone up to it, and it starts extracting the data from the phone and puts it on there. There's also like mobile UFED devices that you can be in the field and on the crime scene and plug it in. So there's multiple ways to get that data through Cellbrite, and what that does is it builds a UFD, and that UFD is more like a index and some supporting information that tells you, hey, in this big package of data, which a lot of times it's in a zip file, and it's the package that the UFD is going to refer to that actually has the databases and the information. So you load that into Physical Analyzer. So Cellbrite has a product called Physical Analyzer, and Insights is their newer version. And you can put the data in there, and that gives you access to the databases. And you can actually do some database, like go through the database and break it down inside of that software as well. You can use, it's called App Genie, so it'll go in and it'll look at the app and be like, well, what can we do with this app? Like, what more information can we gather? Because, again, it's a vendor software, so they're only doing what the people in my field are saying, hey, we need this to be adjusted. We're not getting enough information for this. Can you turn your attention to there and try to get more information? So once that's all gathered, you go in, you're starting to do your examination, starting to find out your bits and pieces, finding out what databases you need to explore more, what information is important. And then the requester, which is usually an agent, a police officer, or auditor, whatever the case may be, they'll want to see everything right away. Unfortunately, digital forensics is not a right-away type field. It does take quite a bit of time. I think 6 terabytes is a lot of time it takes to get through that. So they'll want something right away. You create a reader report, send it out to the requester. That way they have just a first look of like, oh yeah, that's my suspect. Oh yeah, this is a message they talked about. And you can start to get little bits and pieces. It keeps them happy while you're doing the more in-depth stuff. It also allows them to say, hey, I saw a message on this day, but I can't find anything else that's around there. So they reach back to me and say, hey, this date, I need to know more. So then I can hone it in and be able to say, on this date, at this time, looking at these different databases, I was able to determine this or to provide more information. And then from there, you write up a report, you put everything together, and then it goes back to the report goes back into evidence if it's an evidentiary report. Again, you're working off a copy of the data, so the phone's already been put away. You don't mess with that anymore. If the extraction, like you drop a hard drive or whatever and it stops working and you have to re-extract, you still have that. And one of the other things to touch on that, there's a verification. So I know earlier in the trial there was talk about a hash value being a fingerprint. Same thing, whenever it does the extraction, Cellbrite does a hash of the data, and you're able to just click on verify hash value to make sure that you're looking at the same data that you were previously.
So, in reviewing this and basing your opinion, what are we looking at here?
So right here we're looking at this is the UFED reader report, and it has different data located there. So you'll see the file system, which is essentially the background of the phone, and it shows the different areas that databases are in. The one database that we'll look at in a little bit, or information that was supplied from that database, you can see I have typed out there the path that has the com.android.providers.telephony and the databases. If you look in the directory on the left-hand side, it does go in alphabetical order. So,
And Mr. O'Brien, if you
Sure.
want to use your mouse,
don't
click on it though, because of the
No
digital
clicking.
clicking check, but
all right, no clicking.
Oh, yeah,
So,
go ahead.
right here you see com.android Chrome, com.android vending, like wallpaper backup. So that only 3 com.androids were found, not the com.android providers. Like that whole directory structure isn't there to include the database.
So is this a complete picture of this phone?
It is not.
Okay. So did you also review the Armada infotainment system?
So I reviewed the portions of the Brilla extraction that were provided to me, which were the data locations where the vehicle traveled.
And so I'm thinking that we heard testimony about how Detective Campbell was told, or I'm sorry, it was Detective Good was able to go through and kind of hang along how I'm sorry, Detective Spangler, all these guys with these technology and phones, I apologize. Detective Spangler was able to go and follow the infotainment system where the car went, when it started, when it stopped. You saw that, correct?
Correct.
And I believe it was brought up that Miss Michaels was at a car wash around a certain time. I believe it was between 8:14 and 8:24, and the state phrased it as a car wash, correct?
Yes.
And we asked you to look at the points at this supposed car wash, and that's what we're looking at here.
That is correct.
Okay, and we see that the kind of the top half of it, the gas station, it's a convenience store, it's not just a car wash. But what did you do here?
So the first thing I did was I looked here. This is the car wash.
Sorry, y'all. I went and got my coffee, and I got this stuff from Walmart today because I'm addicted to McDonald's sugar-free vanilla iced coffee. Like, it doesn't raise my blood sugar at all. Like, it stays the same. And the lady said that the Jordan Skinny tastes just like the ones from McDonald's. So I bought it today. And I got the McCafe premium coffee. I didn't make that, but I put some of the Skinny stuff in my iced coffee that I had picked up from McDonald's earlier before I started the live. Tastes just like McDonald's. Oh my God. And I only saw a headline about it in the news. I remember you said you were going to cover it, so I didn't read it. I'll wait for you. Okay. Maybe during lunch we can go over it a little bit. Find some things to read up on it. So, now my candles are hazelnut. I love the smell of hazelnut. But I usually do the sugar-free vanilla, French vanilla. But they didn't have French vanilla. They just had regular vanilla. But it tastes really good. I've had 2 iced coffees in like 10 minutes. So we know Ronnie will be quite the handful today. So yeah. Okay, here we go.
You can tell by the structure and the wet marks, and then if you do street view, you can go in and see that as well. So I noticed there's no pings along this backside or anywhere along the car wash area. I also looked at the date and times and the start-stop time of the vehicle.
I got my candle going right now. I picked one up from Walmart. I like the Walmart brand hazelnut candle. Oh my God. No, I don't think it's Walmart brand, but I don't know what kind it is, but it's hazelnut.
Which also was indicative of not really enough time to get a car wash, not in the right location for a car wash. But it did show that there was activity under this canopy, which is where the gas pumps are, and is also where all the pins happen. The locations are all in the gas station area. Coming in from this side, going around into the area here, and then come out and leave that direction.
And just as a side, you shut off your car when you get gas, right?
Typically.
Usually when you're at a car wash, you leave it on, you're sitting there listening to music.
Or having to drive forward, yeah.
Correct.
Or neutral, let it go on its own.
So, turning your attention to another item, did you review video data at 6505 Taylor Creek?
I did.
And what is your opinion of what was recovered from that address?
So again, I believe it to be incomplete just based upon the type of evidence that it is and the devices that it comes from. There are, as you can see on the screen, 2 of them are labeled ring video, and the other one just has what appears to be a date timestamp and a .mov. The others are .mp4s. So the 2 videos on the right, the washed out one and then the one that's more in color, appear to be videos that were extracted off of either the Ring app or like you can go online to the website and pull it down, download it. You can share via email. There's lots of things that you can do with Ring videos. And the one on the left appears to be a few still shots that were then combined into this video that's there. So the snapshots being put together, I'm not sure how familiar you guys are with the Ring camera, but you can set it up so that it does snapshots. So you can do, I don't recall the minimum amount of time, but I believe it to be like minutes, maybe even seconds. And then from there, you can go into, like, you can turn it off completely. So the fact that there are what appears to be snapshots would indicate that snapshots were being taken. And if only 1 or 2 snapshots were taken of that area, and I believe this is the one where you can see the house up on the, or the vehicles on the top right? Yeah.
It's this one.
So in this area here is the area of interest. So if you're having a lot of snapshots in that area, you're going to be able to see things coming and going. So you would be able to refer to those snapshots. However, in this exhibit, I did not see multiple, well, there were multiple, but not a plethora, not a whole bunch of snapshots to look through. It was just, hey, we collected these 2 or 3 snapshots because we see the vehicle there, and then done. But there's so much more that could have been collected on that and more information.
And you weren't provided any document from law enforcement that they were looking for snapshots of this camera?
I was not. I didn't receive any reports or anything on this.
Are you aware that any other videos that had been provided to you, anything else that you saw that was recorded except for what we saw here?
So there were, I looked at a bunch of different videos that were collected.
And let me, from
Sure.
this address.
From this address? No.
And that's because there could have been, but from what you saw, there wasn't anything done about the snapshots or anything. There was just that one.
Correct.
Now, I'm going to turn your attention to one of the phones we asked you to look at, and off of the information that was provided from the state. It was Devyn's phone. Did you review that?
I did.
And I want to get to was it a complete capture of Devyn's phone?
No, same as as previously shown.
There wasn't information about every single app, every single activity that was going on.
There was not.
But even though we had an incomplete picture, you were still able to access some background information, some stuff from the databases that can tell you kind of what was going on.
Correct. I was able to access the reader and what Cellbrite was able to pull out and look at those provided items.
So what are we looking at here?
So here we're looking at on 8/6/2023 at 10:36 at night, there is communications, an instant message that was outgoing from, we're looking at Devyn's phone, so the outgoing would be the from, and then to the phone number related to the device of Devyn. So from Devyn to Devyn, their devices. It says, see you when you get back, I'm going to sleep, girls. So it's part of a text message. And then there's an incoming call at 10:58, which appears to be from Devyn's device to Devyn's device. And it appears that the call was taken and was 44-second long phone call. The last item is at 2:12 in the morning on Devyn's phone. There was part of the Android messaging here. There was a icon, so whenever you save a contact, you can add a picture to it, and just so whenever you look at it, it pops up, has the picture. So this is a picture like that.
And this is a little bit more information on that
Correct.
icon.
Same one, it just Different slide. Same
time stamp.
Yeah, because remember, the defense thinks that Devyn was looking at photos of Devyn and got upset, and that's when he left and went over and did this to his dad, allegedly.
Same time stamp,
date.
same messaging, same area.
And this is just a close-up of the photo of the contact.
It is.
So it shows that there may have been some activity going on at that phone around that time.
Correct.
Now, in your experience and investigation and the roles that you're...
I suppose that picture probably, I would be upset. If I was having problems with my significant other and I was looking at that picture, I would probably be upset. I think anyone would. She's trying to tell me to get out so her baby daddy, my daddy, can move in. Jeez.
Work. Gaming systems and other devices, not just cell phones or computers, but anything with hard drives, anything that's able to be communicated over, that would be important, correct?
Correct.
You would be collecting those things as you go through and see what's at the scene.
Correct. Depending on what the crime is, depends on what you collect. In a murder case, you're going to collect pretty much everything you can. You can do some field assessments and be able to look and say, well, you know, this device is dead. It's one of the examples was a really old, like Nokia bar phone from in the early days. And if you're dealing with a crime right now, there's no power to it. It's stuffed in a box in the back corner and like in a storage unit or something like that. You might not necessarily take it. I mean, you could, but it's more, all right, well, we know that's there if we ever have a need for it. But in general, if you're doing what's considered a major crime, which murder falls under, you're going to want to take as much digital evidence as you can until you start getting more information.
Because in the beginning of an investigation, you don't really know what's going on. You're trying to collect anything that may have evidentiary value to later be examined, or if something comes about the investigation, you have that preserved.
Correct. And even in this case, so there was an additional cell phone, I believe it was Devyn's cell phone, that was, okay, this is too old, the activity is too old, it's not really relevant to the specific focus point of this investigation. So again, collected as it should have been, reviewed, not relevant. So
This is at 2:12, so must have sent this from the pharmacy. Yeah. Why is she doing that? Did she do it on purpose? Do you think she did it on purpose? I wonder if she didn't. She sent this to Devyn on the way home. That's odd. In the middle of the night, knowing he has to get up early for work. Well, and he knows that she's been overseeing his dad. Oh my God. How gross. Come on, people. Get your lives together.
set it to the side. So
here's a picture. It's one of the exhibits that has been admitted for the jury to look at. Just looking at this picture, do you see anything here that of evidentiary value that would bring you to
I can
preserve
see
some
the.
of this
So I
stuff?
see two items in here that could potentially hold additional information. There is a Xbox on the,
And I prepared it a little bit here
Okay.
just for you.
so it appears to be an Xbox here and then a Nintendo Switch here. And the significance of that is that both of those devices you can chat with people. You can communicate. There's multiple ways that you can do that. One of them you'll see in a little bit, like Discord is a really big gamers app. A lot of people that use Xboxes also use Discord as a communication method if the game that they're playing or whatever doesn't have it embedded, or if they just want to save speed or data just to make things more efficient.
But even in like a Nintendo Switch where you can switch out data cards.
You know, Cindy, and I agree with you that the children are going to suffer. Their mom's going to go to prison for unaliving their father. Their mother was married to their brother. I mean, my God, what a story. I'd change my name. If I was those girls, I would change my name and have nothing to do with any of them. I mean, do you think the grandma really has anything to do with them anyways? I know I wouldn't. No. That's gross.
To
all
store
gross.
things and add more games, or even Xboxes with
Okay,
hard drives
Cindy.
pulling for additional space. It can be just a normal hard drive. Those are things that you'd want to look at and see if they were there.
Absolutely, and they connect to the internet, and you can browse the internet as well. So potential for communications that way on top of chat applications.
So going to other things that could have been looked at here, what are we looking at on this exhibit or this slide?
So this is showing that the Discord app was purchased through the Play Store on Devier's phone, and it looks like 4/27/2023 is whenever it was installed. So yeah, it just shows that an additional chat application was on his phone that is also found on gaming systems.
And Discord, I know you kind of briefly touched on it. I'll let you explain that because you're more well versed in that. Can we just go through again for the jury what that is?
One more time, please.
What Discord is?
So Discord, a chat application, you can have it on your phone. You can have, there's multiple places that you can hold that, and it allows you to communicate back and forth via voice or text.
And what are we looking at here?
So this is another artifact related. Nintendo Switch was also found there. So there's an application that's listed as Cellbrite flagged it as entertainment and chat application. So it's another indicator. Hey, it's a possibility that the Nintendo Switch has chat on it. The application also allows for chat.
And that would be something of significance if you're trying to determine people talking about potentially a murder or anything, that you would go and look through all these things and all these apps to see which ones could communicate to other people, at least be looked at and investigated or preserved for a later time.
If you had access to those databases, yes.
And what are we looking at here?
We are looking at one of the applications that is related to Discord. And it's at 8/7/2023, 2:31 a.m. So it was an artifact, a Discord. So you can see Discord up here. So it's at that date and time on Devier's phone, the Discord chat, or well, the Discord program was accessed.
And that was at 2:31 a.m. on August 7th.
That is correct. So it says modified. Anytime the system does anything to the file, then it would modify it because it's making changes.
And briefly, you didn't look at any router logs, did you?
I did not.
You weren't provided with any router logs?
I was not.
Nothing from the Porcupine residents about a router?
No.
That would have been helpful if you would have had that at that address, correct?
Correct. So as previously testified, the router holds information of connected devices. That's really important, especially whenever you're looking at an investigation like this, because if you know what devices have been connected, then you know what devices you don't have, or you can verify the devices that you do have. So you could look at it and be like, well, 6 phones show up on here, but I only have 5. Where's the 6th?
And some of these artifacts that we've seen, this could all be indicative of activity on either the phone or gaming systems. There's something going on, but we just don't know because we don't have the full picture.
That is correct.
And now we're looking at slide 18 on our presentation for the jury. What are we looking at here? Oops.
Okay, so you'll see in the next slide, it's the same slide as previously shown with the missing database. This lays it out a little bit more. So the native message here, which is found in this MMS SMS database, which we've already shown is not located on the reader report. It has a message in it here that says headed there now. We don't have a to, a from, a date. We have no other information other than it was deleted, which, let me clarify that also. So here you see like messages in white, and then you see it in red. The red indicates recovered deleted items. So if it's red or it has this little red X right here, it means that that item is deleted, but the software was able to pull that out of the database.
But does it show a time or date or to and from?
It does not. And again, I couldn't go back to the database to see if there was any more information in there or related stuff around that time, like around that message, or looking at deletion orders, or there's no way to tell more information in the presented state.
But we know it's deleted.
We do know it's deleted.
And this is the slide that we talked about earlier.
Correct.
And it's about the missing databases and the different types of files, the UFDs, UFDXs.
So UFDX, I think that's a new term. New term for here. So if you have a UFD, it's the initial one, like I had stated about having a device, and you're looking at it's the UFD with the supporting data. If you take multiple devices, so in this case, if I was to take all three of the devices that I looked at, I throw them all into Physical Analyzer, I could create a UFDX, which is essentially multiple extractions put into one. So I can open that up, and by doing that, it loads all of the devices, and then I can run searches. Can you go back a slide?
Of course.
Sure. So up here, I can type in a search, and then if I click on this little down here, it will display each device that's loaded in and how many hits there are, and then you can select which device, you can select all, and then you can work your way through it and see where all that search term shows up across all of the devices.
And just because we've heard all these terms and they've been thrown out between yourself and Detective Campbell, what is the most complete extraction that you would like to have had on this?
I would have liked to have the UFD with the supporting files so that I would have access to all of the data and not just the maximum 3%.
And again, you weren't provided with that.
I was not.
Now, when we asked you to review, yesterday we heard from Detective Campbell about it was Detective Good at the cell site location. It was a couple days ago. They said that they only looked until 9 a.m. at that time.
That is correct.
And we asked you to look a little bit further, give or take on both sides. And did anything stand out to you?
There was a location I was like, this looks interesting. Maybe want to take a look at it. Again, I don't have much more information other than the location at the time that was shown. And so I brought it to the attention and
just because I know it's hard for me to zoom in on this, how we have it set up, but if you could just put the mouse on the two little points that we have on there, so there's reasons we're trying to point out here.
Sure. So here is Jonathan's home, and then here is one in the southern part of the valley, more in a remote area, and that is on 8/7/2023 at 10:25 a.m.
And that's a close-up of what you brought to our attention, correct?
Correct. So it's here, and then you have a lot of these washes, and then over in this area you have lots of open area.
So it's pinging near all these open areas.
That's correct.
And that's the date of that is the 8/7.
8/7.
In your review of this, and I know I've hit this a bunch, but this is not complete.
It is not.
There's more out there that could have been done.
Absolutely.
And some of the things that we've brought up, these are things that we would have liked to know more about, we just couldn't get into.
Correct.
That could have helped us.
Correct.
Court's indulgence. Pass the witness.
Yes.
Good morning, Mr. O'Brien.
Good morning.
We just met outside in the hallway.
You did.
Thank you for your military service, sir.
Thank you.
I have a few questions for you, not too much. I just received these items that were shown this morning. You agree with that?
Yes.
So I'm just going to kind of go through a couple of the slides and try to make sense of, well, to clarify what we're actually seeing.
Okay.
So I'm going to start with the residential neighborhood, the slides you just put up. Mike, can I plug you to keep that PowerPoint back up?
And you can click on it too if you need to just use it on here.
Yeah, perfect.
And just, yeah, I mean, you can click on the slides below and it goes up.
Perfect, thank you. So I'm showing the slide that you'd agree that's a residential neighborhood, correct?
Yes.
And you looked at a whole lot of stuff in this case. Would that include text messages on Devier's phone?
It would.
We got a bunch of text messages after 9 a.m. On August 7th of 2023 from Devier's phone.
Correct.
And you'd agree with me, there's text where he's talking with his boss and talking about a job and going to that job.
Yes.
Okay. And you'd agree this is a residential neighborhood, a newer one, kind of out at the tip of the valley.
I would.
Okay. And the location data is that you're looking at that caused you to testify that he was in this residential neighborhood was from the CDRs, not from the device.
That is correct.
So CDRs, as a reminder, those give a general approximation. They're not like the breadcrumbs from the Burla or the Google.
It's not the GPS, guys.
Got it. So you're not saying in any way to this jury that his location put him in any of these desert areas, correct?
That is correct.
Okay. You indicated earlier that you reviewed not only the DFLs, which were the actual phone extractions, but you also reviewed the CDRs and the Burla, correct?
That is correct.
Did you also review the Google,
I did.
the geofence stuff?
Yes, I
Okay.
did.
You would agree that there's nothing in any of those sources of information that shows Devier's phone going toward or at the Paladura address between 10 p.m. on the 6th and 8 a.m. on the 7th?
That is correct.
Okay. You would agree that all of those things show the defendant's device, car, and everything at the Paladura address until 2:04 a.m.?
That is correct.
So the Google data is separate, and that was a geofence,
Yes.
right? And there, you're familiar with the steps and Google's privacy and
I am
all
the
that.
obfuscated numbers and doing the 2-3 steps.
Right. So just to narrow it down and like simplify it, a geofence is actually placed on around the home, the Paladura home, and says, the first step says, show us what devices are at that home, but they give general numbers.
Correct.
And if I oversimplify it, you can tell me.
It's good.
Okay.
That works.
And so, in this particular case, it only showed the defendant's device at that home.
Well, it showed multiple, but once you select which one you want that's of evidentiary value, and yes, that was
Yeah.
one of them.
And that would be Yoko's, Yoshida's, and Jonathan's were actually there too.
Yes.
Yeah, and nobody else's.
Not that I recall now.
Yeah, so it's 4 devices at the Paladura home, not including Devier's.
Correct.
And Devier did have a Google device.
Yes. An Android that,
Yeah, Android is a Google
Yes,
device. Okay. So we're in agreement, nothing at all that you went through suggests Devier was at the Paladura address between those time frames.
that is correct.
Okay. The Google data did show John's phone traveling from the Paladura address at around 2:04 a.m. in the same exact path as the defendant's car and phone.
Yes.
Real briefly on the car wash. That information was gleaned from the Burla.
Correct.
Burla is the one with the breadcrumbs.
Correct. It does the GPS locations, which is the most accurate.
Got it. And that shows the Nissan going to what appears to be the gas pumps, not through the car wash.
That is correct.
We're in agreement. Okay. And that would have been about, correct me if I'm wrong, I think 8:30 in the morning?
Yeah, I don't recall.
Well-
It's back a few slides.
Okay, it's after the body's discovered.
Yes,
We agree there. You would agree that people can hand wash their cars, correct?
correct.
And there were several hours before homicide detectives made their way to the Porcupine Rim address.
Yes,
So, doesn't look like she went through the Funnies car wash?
yes, correct.
Fair, okay. Briefly on the ring videos. Were you here, because I've seen you a couple times, were you here when the detectives talked about those videos?
I'm not sure if I was in the courtroom or if I
Okay.
was watching from another location.
I'm not going to try to recite what they said about the videos, but simplifying it, they basically said, we got what the homeowner gave us.
Correct.
Okay. You're not suggesting to this jury in any way the cops lied about what they got?
No,
Okay. We're in agreement there.
correct.
They got what they got from the homeowner, and there's 3 clips, one of which looks like it's like motion picture, basically. It's like stills one after another.
Correct.
Which all video actually is,
Technically, yes.
right? And you would agree with me that homeowners or people who have ring cameras, they can change the sensitivity settings on their device.
Yes,
If they don't want to keep getting annoyed with every time a car drives by, they can lessen the sensitivity just to kind of encapsulate their driveway.
you can set up boundaries, you can set up, there's lots of different
Yeah,
settings. that
there's
you
a
can
ton
choose.
of different settings.
Correct.
You would agree that in the videos from that same camera at night and in the morning, it appears Devier's vehicle is in the same exact spot.
To the best of my recollection, that is
Okay.
correct.
And on top of that, there is video from the entrance, the only entrance and exit a vehicle could go at the Porcupine Rim address.
To my knowledge, that is correct.
And that is continuous record, that's not a motion camera.
I'm not aware of the settings.
Okay, there may have been testimony about that, fair enough. So I want to get to slide 10 and, well,
You want me to help you? You just go to the bottom of it.
Okay.
And slide it over.
thank you. Slide 10. So the 3 rows represent an instant message, row number 1, an instant message from Devier's device to the defendant, see you when you get back, I'm going to sleep, girls, correct?
Correct.
The second one is an incoming call at 10:58 PM from defendant's phone.
Correct.
And that one says 44 seconds.
That is correct.
The third one is an image that you brought up today on August 7th at 2:12 a.m.
That is correct.
And I believe the language you used was, I wrote it down somewhere.
I love how he's going to try so hard to debunk this man. Just wanted to remind everyone that thank you for being here. Don't forget to like, share, and subscribe. Who's all in here? Can you say hi in the comments? Let me know you're here. Let's talk. Let's talk about the case.
Did you say accessed? What, just tell us, what does this mean? Like, this,
So that particular picture, the PNG, was the device accessed that. I don't have more supporting information about anything else that was happening at that time, again, because I don't have that database, but something was done with that particular file at that particular time.
got it. So we understand though, when you use that terminology, are you saying the device accessed it or a person accessed it?
Unable to determine.
Okay. If a per-
I can say that, like, the device shows that there was some sort of activity on that.
Yeah, and just so we're clear, a device can do things in the background, can access, can cache, can do all these different things, correct?
Yes,
if it's the opposite, if it's a person accessing it, you would then agree with me that at 2:12 a.m. a person is with that phone using it.
You stated that a person was, to show that a person would have to be there?
Yeah, absolutely. I mean,
Yes.
it seems obvious, but like, there's two alternative theories. It's either the device access it somewhere in the background, or a person is actually handling their phone at 2:12 a.m.
That is correct.
Okay. Go to the gaming system. So you pointed out a couple of Nintendo Switch and an Xbox, correct?
That is correct.
And there were, to your knowledge, no gaming systems found in the other home, the John's home.
I am unaware.
Okay. I guess the pictures of John's home will speak for themselves when it comes to that.
Correct.
You're not taking a position on that. Do you know if the defendant had Discord?
I do not know.
Did we get a full extract on defendant's phone?
We didn't get a full extract on any of the phones.
Okay. What is it that allows you to get a full versus a not full?
So the initial extraction that I talked about, the UFD, is the extraction. What we've been presented with was the UFDR, which is after that extraction is done, then you can either select all, or you can like handpick what you want and then create that reader report.
Okay.
But to clarify, when you're selecting all, it's all the data that piece of software at that time is able to interpret and put into a report.
Got it. And so are you suggesting to the jury that the detectives picked and chose what they took? Or are you suggesting that...
I'm not really suggesting anything other than the full set of data was not provided and I was unable to do a full examination based upon the lack of data.
Okay. And in prior cases, you have a bunch of experience. I have some experience with phones, not nearly as much as you, but there are many, many times in which you cannot get a full extract out of a phone.
Yes.
Right? That's not abnormal.
Correct.
And you're, again, not suggesting the detectives, like, only pick certain things out of the devices.
I have no knowledge what
Okay.
actions they took, but
Okay. So with the text here on slide 18,
okay.
you said this is an artifact with no other information at all.
No other information presented in this manner on the reader report.
Right. So you would agree that there are...
Did you guys hear me talk? Was I unmuted? Because I can't remember if I unmuted or not. God dang, I drink too much coffee. Oh, gosh, I hope so. I read the comments. My bad. Devyn did not send the pic to him. Devier accessed it. So was it Devier and Devyn or Devyn and Johnathan? I can't remember. At 2:12 in the morning, so he was still awake. Yes. I tried telling you that he was awake. And he was on his way over to his dad's, allegedly. To my opinion, I think he was. Sorry, between my son and my grandson both called me at the same time. Well, at least they called you. I hope I ain't repeating myself. At least they called you. Amy's been kind of a butthole the last few days. I don't know what's wrong with her. I don't know if her and Haley are having problems or what's going on, but she's been kind of distanced to me, so I don't know. I might have said something wrong. She gets upset so easily. She's very emotional. But yeah, I can't remember. Oh, okay, good. I'm not repeating myself. So I did forget to unmute. See, that's why I hate muting, because then I forget to unmute, and then I tell you guys to talk to me, but I'm muted when I'm talking. Oh, okay, here we go.
Text messages, call history, all that from Devier's phone, because we've seen a bunch.
I got to use
right.
the ladies'
There's also
room. I'll
that
be
same
back.
type of information from the defendant's phone.
Yes, all
Right.
the phones, correct.
Okay. The text history for Devier's phone goes back years, right?
It's quite far, yes.
And he has a bunch of contacts saved in his phone like we all do,
Correct.
right? I don't even know the number, but like dozens, hundreds, I don't know. Can you see it on that?
If you go back a slide, maybe? I'm not sure if it was captured on that or not. So before the bar shows up in a minute?
Yeah. Let me help you. Do that animation.
Oh, gotcha.
I don't know how to pull it off though. There you go.
There we go. Thank you.
No, I didn't capture the contacts on there.
Yeah, but it is captured somewhere in.
It is part of the reader, yes.
Yeah.
The reader file has that.
And so you agree with this headed there now message? That could be to any number of people, years back, 5 years ago, 4 years, whatever it is.
That is correct.
Okay. But you got to bring it up because, I mean, it's something. But you would agree with me, I'm showing you admitted exhibit 666, that,
Yeah, come.
oops,
Come on.
that with,
It's not quite exactly at the HDMI cord.
gotcha. Can I approach?
Yes.
Does this appear to be to you one of the,
Okay, I'm back.
Or the text string that the parties admitted between Devier and defendant?
That is correct, yes.
and this shows a relationship text,
8523?
8:05 at 1 a.m. already.
Thank you.
Yes.
This next one is from voicemail to Devier.
So voicemail being the owner
I
of
think
the
I'm
phone.
good on the coffee
And it
today.
says, where the WTF are you? You obviously ain't home, but you ain't cheating, exclamation points.
That is correct, I see that. And
August 5th,
2023 at 4:02 a.m.
okay. And then the next text says, from Devier to the defendant's voicemail, see you when you get back, I'm going to sleep, girls are in the living room, correct?
Gee, after all that coffee I drank, I probably won't sleep now for the month of Mondays. I do. I drink a lot of water every day. I probably drink 10 bottles of water every day. I fill up my little blue thing here. I have this thing here. I'll show you. Hold on. I'll show you. Because I got to do this for fair use anyways. See my water? Can you see that? Can you see my water? I fill this up probably 3 times. So yeah, I'm a big water drinker. You have to be when you're diabetic. Yeah. I love water. Okay, Cindy. Thank you for being here today. I was hoping you were going to stay so we could watch some of the news stuff on that boy. But it's okay. People have lives. I don't. Just YouTube. All right.
That is correct.
Okay. No other text saying I'm on my way, or I'm sorry.
Come on, jump.
No.
Jump, Leah.
The CDRs
Oh, okay.
are completely separate from the device. That's the phone company
That
keeping
is correct.
record. And you would agree with me,
Yeah, my dog's going to be extra needy today. She had a really bad seizure this morning. That's probably why I'm a little anxious today. It was really bad. I didn't know she was going to come out of it. I was really scared.
that there is absolutely no record of a text message after
come here.
the one where
Over
he
here.
says, I'm going to sleep, going to
Come
the
on.
defendant's home between whenever that was, 10:36:24 p.m. and 8 a.m.
Can you repeat the initial question?
The CDRs. So
Okay,
we're-
CDRs, that is
We're away
correct.
from the phone.
Yep, that is correct.
In the CDRs maintained by an outside
don't
source
do
of the
that,
company,
because you know
there is
must-
no incoming text to Devyn
No,
from
we
Devier,
talked to the vet.
no outgoing text from Devier to Devyn.
We talked to the vet about it, and it's like when she just I don't know. It's because her brain is really small. She's a really small dog. Okay, see you in a little bit.
After that one at 10:36.
Based on my review, no.
So this headed there now text doesn't have anything to do with our time frame, based on the CDRs.
Leah,
Based on CDRs, I believe that is correct.
Just make sure I got through all of them. Yep, that's it. Thank you very much, sir.
Sure.
Just to touch base on the picture being accessed and the gaming data of, I think it was, what's it, a Discord? There was activity the morning of, or the early hours of August 7th.
That is correct.
And do you know if Devier had his phone on him?
I wasn't there. I don't know.
Yeah, we don't know either. Now, the state brings up the Funny's Car Wash. Let me pull this back on this slide. Now, he brought up the state, and I'm not trying to misstate, I'm just kind of summarizing, is about pulling in a potential hand wash of a car or something like that. You remember that question?
Yes.
Now, the car turns off at 8:17 and turns back on at 8:21. Does that sound about right?
It does, yes.
Nissan Armada is not a small car. It's not a Honda Civic. It's not a hatchback. It's a pretty big car. Correct? Just from your, I mean, you've seen them on the road.
Yeah.
It's a bigger SUV. It's not a small
Correct.
car.
That's correct.
So to hand wash a big SUV that they've made is super clean, that 4 minutes is pretty quick.
Correct.
To hand wash a car, not drive through a car wash, but to hand wash it at a gas station, unless there's, yeah, doesn't seem to add up.
Correct.
When he asked you about the Ring cameras at Porcupine, Mr. Giordani asked you about the cameras in and out of the development. Remember that line of questioning?
I do.
But we don't know if any person was walking around, say, hopping a back wall on a side of the house. We don't have any of that, right?
I did not see any of that, no.
There's other ways to get into a neighborhood besides just a car coming through the main gate or the main entrance
Correct.
or leaving a neighborhood.
That is correct.
Now, there was a call.
Just to clarify, you said car or person?
I'm sorry, there's other ways for a person to get out of a neighborhood besides a car.
That's what I
through the
thought
main
you were
gate.
saying.
Yeah.
Okay,
And thank you for clarifying.
sure.
And we do see that there was a call at 10:58, right?
That is correct.
And that was Devyn to Devier.
Yes. Well, to the devices.
Correct. Now, we went into the UFD, UFDR. Like I said, I always confuse these, so I'm glad you're here. We were not provided, you were not provided with the full downloads or extractions.
That is correct.
And from Detective Campbell, yesterday he testified that he got his extraction and gave it to Detective Ozawa. It's kind of what you remember, because you've looked at the reports, you're familiar with the case.
Yes.
Do you remember seeing, or do you remember being handed any kind of information with phones that there was a follow-up from Detective Ozawa to get more information on the phones?
I did not see any more.
You were just given the initial UFDR of the phone.
I have no idea when those, I can look up the time that it was created, but I don't know what order, if there were other extractions done. I have no further information other than I received these reader reports.
So from what you received, it is just, I have this one download, and that seems to be the only thing that was done. From
Correct.
what you've been
From
given.
what I've seen, yes, that is correct.
Now the headed now text, it was deleted, wasn't it?
It was.
And we don't have a time.
We do not.
We don't know what that's in reference to.
No.
And going back to the ring cameras at Porcupine, or from the address, there's so many. The Taylor Creek address.
Okay.
Okay, welcome back, Cindy. That was quick. But yeah, no medicine. They said when she gets she was just cleaning herself, like a normal dog would. And she just overexerted her brain. Like sometimes running or playing or stuff like that will put her into a seizure. They said that because they're just here and there, but if she had them all the time, then yeah, then he would probably put her on some medicine. But thankfully, no. God, I can barely afford my own medicine. Could you imagine if I had to buy for the dog too? Jeez. Okay, back to it.
Not suggesting that the cops didn't, not that they made their own, but there was no follow-up on to subpoena or get any more information on this. You didn't see any of that.
I have no knowledge of that, no.
And I'll state it this way, you weren't provided any more than that. This is.
So what I'm gathering is this looks really bad on the state if they weren't willing to share any more information with the defense. So he's making it known that, we weren't going to share the whole downloads with the defense because maybe they might find something that might be incriminating to the state. Might say that our case isn't good because they found this or that or a text. Yeah. So why didn't they give the full downloads? So are they hiding something? So if I was the juror, I'd be thinking, well, why are you hiding stuff from the phone? My daughter's girlfriend put on Snapchat that she got jury summons. So she has to go be a juror. All right. I don't know if I'd want Haley to be my juror. She'd send me right to the clicker. All right.
This is what we got, and we gave it to you.
Correct.
Okay. And just going back to this picture of one of the last pings on Devier's phone, the state suggested that there was this, he had this work schedule, which been throughout the course of the trial, there's been testimony that he had to work, that morning.
Oh, no, I know. I got picked to be on a jury one time. The guy, they had to say it was burglary because he assaulted the security guard for the mall. And unless we said that he assaulted him, they couldn't charge him with burglary. So, but he did. He got sentenced, I think, to 10 years.
and he went. But were you able to confirm that by any text message you looked at through the phone?
I want you to put this.
Nothing
on
popped
the
out to you.
No, nothing stood out to me.
It's kind of why this popped out to you by this area at this time.
That's correct.
God damn.
No further questions.
The fucking coffee's got me all.
I have to apologize.
Yeah.
So
Ugh.
there actually
really got
is
called
text
for
messages where Devier is talking to his boss and saying, I'm headed to a
I don't know
job
what's
out.
wrong with Amy.
You saw those, right?
Yes.
Okay.
Says one
So
or
those
two
do
words
exist.
to me,
Yes.
That's it.
It's not just testimony.
I don't know if
that's
her and
in the
Haley were
device.
It's
fighting.
in the
I-
device. There's multiple occasions that they talk about work. Hey, I'm headed to this side, headed to that side. I'm going to run late.
Yeah,
That
she's
morning,
good.
August 7th.
I don't recall specifically.
I'm about
I
what?
can show you.
Okay.
Yeah.
Can we
she-
agree
enough.
overall
You don't
that
need to think.
you went through these devices like with a fine tooth comb?
No. I did the best I could in the amount of time that I was provided
Okay.
with the data that I was provided.
Okay, fair enough. When you go through this, I mean, you're presenting everything that stands out to you as like, this is fishy, or this is something I would bring up, or whatever, right?
Correct.
There's nothing you left out that was something you were like really interested in and didn't present to the jury?
No.
Okay.
Oh, my neck is.
So,
That's the component right there.
so I'm sure you already admitted
I don't have
Exhibit
to go in
4.
the car with you. Oh,
And I want to kind of show you this just in context of the timeline you just provided to the jury. So
It's more, you only
we
looked
agree
inside.
that there is an an incoming call to Devier's phone at 10:58 from defendant's phone.
Correct.
Monday.
10:58 PM on the 6th.
10:58 p.m. on the 6th, 44 seconds.
Fucking light again.
And this is already admitted earlier by us.
Rubbing it. Oh,
You-
I got that fucking phone right
Well, let me
here.
back out so you can verify.
You see where I scratch it?
You would agree that
Feels
this
like it's itchy,
appears to be stuff from the defendant's phone, correct?
but
Does
it's
he-
not. It's
Based on the naming.
Phone's
Yes.
hurting.
And then I'm gonna go into the
Thank
call
you.
log timeline.
Oh, that's okay. We were just talking about how my neck is hurting me.
And
I'm
you
like,
can
rub
see
here,
that
keep rubbing.
10:58 PM
That's okay. He was just putting,
outgoing call from the defendant's
Yes.
device to Devier, correct?
and I'm gonna try to get some from the
see?
pharmacy
Yes.
or from the doctor.
And then as it
See the
goes
light
on, there
again?
appears to be a bunch of
But
missed
not the
calls.
patches, and I
from
can't
Michael's.
keep buying
That is correct.
these,
What's
patches.
labeled as Michael's home?
Right, but it's a different device from Devier. It's a
Correct.
separate number, yeah.
Correct.
He was putting this on my neck.
And some of those went to voicemail.
And these ones right
Yes, that is
here
correct.
are
I
$10.
believe 3, maybe 4.
3 of them.
And you're aware we plan to cover those.
I'm gonna
voicemails
ask
when we
if I
back.
can get,
Absolutely.
the prescription 5%. I have the 5% lidocaine,
Opening the folder
but
entitled
the
Audio.
lidocaine rubs off really quick. So get that.
Do these
I was
appear to
telling
be
him to rub my-
the 3
my
recovered
neck. He
voicemails?
forgot a spot.
Yes, it does.
And these
That
are
bone, it just hurts so bad.
after that 10:58 PM call from the defendant to Devier, correct?
Correct. It
Yeah, I know.
appears to be
I
about
don't use
11:13,
the nitrous
11:18,
oxide, but
11:20.
It wasn't nothing bad.
And if I click on this, is that going to play the audio?
I hope so. It doesn't have the supporting file.
Yeah, I did this before, and I think I had to open it. I didn't.
God, they can't even give them the file that it supports. I'll have to go through and edit that out. But I don't think I said anything bad. I don't know.
Mom, if you answered this for me and walked to me, I woke up in the middle of the night, there is a sleeping kid. Please, I can't fall asleep now and wake everyone up. Please give me a call back.
Did you hear that?
I did.
You familiar with that?
I am.
That's, sounds to be a little girl's voice.
It does.
And she's saying, Mom, Devier's asleep. I woke up in the middle of the night.
Correct.
Victoria, can we somehow move that up? Because I have the represent.
Well, good thing I didn't start moaning like I usually do when he's rubbing my neck. Now that would have been funny.
I don't know why the audio is not playing.
Because my laptop's
No, I unplugged it.
May I inquire if the jury heard that?
Yeah, did you guys hear that?
Okay.
Yes. And Mr. John, if you want to put the laptop next to the microphone, and then make it louder.
That would make sense, wouldn't it?
Yeah. Here we go.
I have the same water bottle.
Mom, I've been waiting for you to come home, and I haven't seen you in your work. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got a car accident or any certain things. And I'm getting very worried. Please call me, please. Everyone knows me. I woke up in the middle of the night. I can't fall asleep. I've been trying to get everything prepped for school tomorrow. So, the rear knocked out and it's knocked out. I can't fall asleep. He's been telling me what you got here to everything. You said you were going to get some medicine. And then you never got any. So please give me a call back. I'm very worried.
That was voicemail number 2.
Oh my God, how sad is that? That poor little girl. Why are they playing this? This is going to be all over the internet now, and this little girl's voice is going to be everywhere. She didn't ask for that. They could have muted. Oh, I'd be so mad. Oh, poor little girl's worried about her mom, and she wanted to prep for school, and she told her she forgot her medicine, and oh, poor baby.
Sir?
Yes, that is correct.
And you heard the little girl's voice say, everyone's asleep. I woke up in the middle of the night.
Yes, I did.
Devier's knocked out.
I don't think she said that, but
Okay, well, I'll play it again then.
Mom, I've been waiting for you to come home, and I haven't seen you in your work. So, if you could, please give me a call. I'm very worried about you. I'm very scared. I don't know if you got a car accident or any certain things. And I'm getting very worried. Please call me.
Oh my God, an 8-year-old should never have to worry if her mother was in a car accident. Oh, how sad. And she really loved her mommy. And her mom, wasn't very nice to her either. From the CPS reports, her mom was not nice to her. And look how much she cares about her mom. It makes me want to cry.
Please. I don't know if I woke up in the middle of the night. I can't fall asleep. I've been trying to get everything prepped for school tomorrow. So, the radio knocked out and it's knocked out. I can't fall asleep. He's been telling me what you got here to everything. You said you were going to.
You heard that time?
I did. Thank you.
Sure.
Oh, Oh God, it's just sad. No, because I think she knew what mom was out doing.
Mom, I've been waiting for you to come home. You never came home. I don't say you don't come home. I just said I should be better. I'm very worried. Please call.
You know, I hate to interrupt again, but I'm going to say this right now. I never missed Amy's phone calls. I seen her calling. I picked up that phone immediately. Whether she be 8, 9, 10, or 22. I pick up that phone call.
I'm very worried. You know how you're worried about me sometimes? I'm kind of worried about you scared and everything. I'm really been worried. I'm like so, like I was in a car accident or something that's not worried. So please can you call back? I did call in the neighborhood and it's not in front of our house. I'm not sure if it's you. If it is, can you call me back?
And that was voicemail number 3.
That's correct.
And then if we back out of that, we go to the report. That would have been, for the record, 11:13 p.m., 11:18 p.m., and 11:21 p.m. in that order, right?
That is correct.
And her mom still didn't come home for hours. Could you imagine sitting there waiting for your mom?
Those messages were around 11 p.m. is what you recall?
That's correct.
There's activity on Devyn's phone around 2 a.m.
That's
Correct. On 8/7.
That's correct.
And in one of the voicemails, it talks about a car out front. Is that what you heard?
Yes.
Exactly. Mom should have been home getting the kids ready for their first day of school. Exactly. She should have been at home, laying in her bed, waiting for her alarm to go off to get the kids up and get them excited and have a good morning, make them breakfast, and get them on their way to school. I mean, my God, could you imagine having to go through that the night before you have to go to school? Okay, Cindy.
Now, going back to the wash, the state brought up about his work schedule. Do you remember reviewing any messages between him and his boss regarding that morning?
I really wasn't focused on anything that late. It was just over my review of like going through, like, oh, that's kind of weird. I didn't really do a lot of investigation around that because there was a whole lot of stuff, other places that I was focused on.
Anything about him running late?
Not that I recall.
And we saw those artifacts on the phone around 2 a.m. with the Discord and the photo.
Correct.
And we can't.
The photo, yes. I'd have to see the Discord get one again to verify that time.
Pull it up.
No.
Looks like Discord was 2:31.
Okay. Welcome
That,
back.
I have no reason to dispute that.
I'm sorry. I don't know what just happened now. There it is.
2:31 a.m. Discord? That is correct. On 8/7.
Court's indulgence. There are no further questions.
Any follow-up statements? Okay, ladies and gentlemen, jury, have any questions for this this witness. Okay, Vice Clerk, on 4 sheet of paper with your name and your jury number. Counsel can approach.
I don't know what that thing is up here. Why they still have it. Or is that from me? What is that? It has to be long crime. I tried clicking and it don't go away, so. Look at that little tiny pencil they give her to write with. I can't pass. Oh, I can. Oh, Leah. I got Leah sitting on my hand.
Database?
Okay. Mr. Horvath, any follow-up based on your question?
Of course, the ordinance.
Okay.
The dog is sitting on my hand. I can't move. I can't get it to. It's okay, Leah. It's okay, baby. No, stay here. Okay, I think they're coming back now. It's okay.
Does the Discord photo at
Can't link
2:41 a.m. show someone accessed it from the Porcupine home?
There is no indication of where that came from.
I'm sorry.
I don't know what it is.
No indication of the location of where that came.
When you look at the Burla data, did Burla show Devyn going straight into her neighborhood and to her house?
Okay, I got rid of it.
One more time, please.
It was
When
me.
you look at the Burla data, did the Burla show Devyn going straight into her neighborhood and to her house?
I believe I need further clarification, like what time frame, or if that could be clarified more?
I have to read it directly
Okay.
as they look. Was there any stops in her neighborhood?
None that stood out to me now.
When using chat applications such as Discord or others, if the phone is set to show notifications, will this create activity records even if the phone is not being used?
Yes, it houses it in a database, which, again, I didn't have access to that database.
Okay. Mr. Horvath, any follow-up based on your question?
Of course, the ordinance.
Okay.
They should have asked why he didn't have access. Yep, they should have asked, how come you didn't have access?
Your Honor. So the pending question at 2:04 when the Armada leaves Paladura, it goes to the pharmacy, correct? That's what you reviewed?
Yes, that is correct.
And then it goes straight home.
Yes,
That's it.
that is correct.
No other stops.
Not that I saw, stood up, no.
No further questions.
State any further questions based on your question?
Just briefly, you'd agree with me that the Nissan Burla data is specific to the car, correct?
Yes, that is correct.
Nothing about that or the phones is going to show whether the defendant got out of her car with a basket, with a head in it, walked over to the neighbor's house and dumped it in trash, correct?
Potentially, Barilla could pull information about weight distribution and like, you know, how if you're in your car and it says, hey, there's something in the back seat, make sure to check it. Potentially that could be there. I didn't see any, only information I got was location data.
So human head weighs about 8 to 10 pounds, would you agree?
Sure,
If a doctor testified to that, we can agree.
sure.
Are you saying that the Burla would show an 8-pound differential? Or,
No, I mean, it's dependent on the car, so I don't know what the setting is on the car, but it's possible.
okay. So you have nothing to suggest that the defendant's car stopped anywhere else?
That's correct.
We've already talked about
CVS and then,
Yeah.
correct.
And she can, whatever she did after she got out of the car, you have no evidence of that?
That's correct.
Thank you. Pass it.
Just real quick, in cars, seatbelts, in the newer cars, this car looks like it's a newer car. Sometimes when someone is less weight, you know, it says buckle the seatbelt, or they shouldn't be there. You've seen those at mornings, right?
That's correct.
Do we know if this car had this?
I don't know, I was not
Didn't have
provided
a full-
information.
And then just like the car, if you don't have your cell phone on it, you can't track that person if it's that person's phone, if they're supposed to have it on them.
Say one more time, please.
You can't track a person by their phone if they don't have their phone on them.
That's correct.
Thank you. No further questions.
Oh, duh.
Follow-up statement?
No, thank you.
Do ladies and gentlemen, do you have any further questions for this witness?
Yes, I have a question.
Well, excuse, thank you very much for your testimony here today.
Thank you, ma'am.
All right, ladies and gentlemen, we are going to take one brief recess for the morning. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merit, either by voice, phone, email, text, internet, or other means
Oh,
of
good.
communication.
Are they taking their
You must
lunch?
not leave off listing news or media accounts and commentary about this case. You must not do any research, such as consulting dictionaries, using the internet, or using web materials. You must not make any investigation.
Oh, shoot.
Test to the case, recreate any aspect of the case, or any other way investigate or whatever about the case of your own. You must not express anything regarding this case, so it's constant to you. Ladies and gentlemen, 10:25, be recessed to 10:40.
All rise for the jury.
10:40? Oh, they should be coming back. 10:40. Yeah, they should be back. It's 12:40. So what do you think, Kathy? Do you think the state was keeping them from information? What's going on here, Kathy? What are they saying in law and crime? Hold on, I'll be right back. I gotta go to the women's room again. On? Okay, I'm back. Oh my God, they're still not back. Get up, Leah. I haven't checked the chat. But I think he had the exact same info as the police did. Why does he keep saying that he only had limited info? I don't know. You don't have YouTube on your phones, Kathy? I broke my nail grocery shopping today. Apparently it's a sport. What time they coming to get you? Your phone is tiny? What kind of phone do you have? I have an iPhone 11 Pro, and I have a Motorola, and I have a Samsung. Oh, wait. Is it a Samsung? I don't know, but the screen is huge. Oh! I didn't know I
Please be seated. Your Honor, the jury's all present and accounted for.
My bad.
We are back on the record at scene. We said 7239 State Level, Devyn Michaels. May the record reflect that Ms. Michaels is present with her attorney, Deputy District Attorney on behalf of the state, and both parties stipulated to the attorney.
Yes, Your Honor. Housekeeping matter, we have stipulated medical records.
Okay.
I'd like to make part of the record.
Okay, what are the exhibit numbers?
Okay. There's
C4 and D4? Okay, C4 and D4 will be admitted pursuant to stipulation. Defense, you may call your next witness.
Thank you. The defense calls Dr. Larry Sims.
Dr. who? Larry Sims? Where's my call? Oh. Dr. Larry Sims. Well, good. I hope he talks about her memory loss. Well, let's hope it's her doctor. Oh no, he's 100 years old.
Testimony about taking this action will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please be seated. Please state and spell your name for the record, please.
My first name is Larry, spelled L-A-R-Y. My last name is Sims, spelled S-I-M-M-S.
Whenever you're ready, Mr. Director.
Thank you. Dr. Sims, if you could tell us a bit about yourself, beginning with your education.
Well, I graduated from high school in 1970. I graduated from college in 1974. I went to medical school at Oklahoma State University and graduated from there in 1978.
A year I was
I
born.
did a rotating internship as a physician in Dallas from 78 to 79. And I was a general practitioner for 10 years, 3 years in rural America and 7 years in Detroit. I had about 55,000 patient contacts, delivered about 100 babies. Then I went back into training at Michigan State University in pathology for 4 years. Then I did a 1-year forensic fellowship at Cook County Medical Examiner's Office in Chicago. Stayed on there for some years, and then I came out here and was at the Clark County Coroner's Office for 19 and a half years.
Whoa.
I maintain a licensed medical license in Nevada, and I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Doctor, so you were a coroner here in Clark County?
Yes.
19 and a half years.
Yes.
Would often be called by the state of Nevada in prosecutions of murder cases.
Oh, yeah, I would, I probably testified over 500 times during that period of time.
Were contacted and were ultimately retained by the defense in this case, the state of Nevada versus Devyn Michaels, correct?
Correct, yeah, I was contacted by the Special Public Defender's Office, it's been over a year ago.
Okay, and just for the record's clean, I mean, I'm not part of the Special Defender's Office, nor is Mr. Horvath, but that was who was initially on this case.
That's who initially contacted me.
Ooh,
After being
favor, lawyer.
contacted, were you provided with certain materials, specifically an autopsy report and other things of evidentiary concern, photos?
Yeah, because aren't they the same legal team that worked on that senator or the guy that unalived his neighbor? God, what, Tunis? I can't remember, but wasn't he the lawyer for that?
And the like.
Yes.
To your knowledge, was it the entire file?
Well, what I was provided, which is all the forensic important stuff, yes.
Have you had an opportunity to review the autopsy report prepared by Dr. Stephanie Yagi?
Yes.
And that autopsy report is dated August 8th of 2023.
Correct.
Did you review the pathologic findings in the autopsy report?
Yes.
And what are they?
Well, okay, have you got a copy of the autopsy report? I can go.
Absolutely. May I approach with the copy? State any objection?
No.
Yo, she's playing games on her computer.
So the main two findings is she classified the death as homicidal violence, and then she noted that he had a fatty liver.
And those were the two findings?
Correct.
Now, are there certain standards of practice that are employed by pathologists, specifically coroners?
Yes.
And what are those, and if you could please describe those to the jury?
Well, there's a number of practice standards, but there's a specific published practice standard in relation to using homicidal violence without any specific cause. It was published in 2010, and it has 5 separate criteria
She's waiting.
that all 5 have to be present before you use a non-specific cause of death, such as homicide by unspecified means or homicidal violence.
And doctor, what are those 5 criteria, and if we could just have you break them down, please?
Well, one of the important ones is that there can't be any other cause of death present. In other words, there can't be any natural disease present. There can't be any toxicologic explanation of death. There can't be any environmental explanation of death, such as drowning or cold. And there has to be an indication that the body was altered in some way.
I just played Monopoly.
And there's one
Now I'm
other
playing a word
criteria.
find game.
I can look at the paper. I can't remember what it is.
Okay, if I may approach the witness.
And then a specific cause of death can't be brought out of the whole entire data set, which means all the findings that are available. So.
So, from the get-go,
Don't forget to leave the
we have this pathological
wait,
examination done, and we have these pathological findings. The first being homicidal violence. And you had discussed these 5 criteria. Let's focus on 2 of them, specifically no atomic cause of death. How is that a concern, and how did this examination and this opinion not follow the standard practice?
Well, there are, in this particular case, that he actually has 2 natural diseases that could cause his death. His heart was enlarged, and he had a fatty liver.
And those are obviously borne out through Dr. Yagi's analysis and review of the body, correct?
Correct.
There's another criteria I'd like to draw your attention to, and that's no toxicologic cause of death. If you could please explain that and the significance in this exam.
Well, there has to be drugs can be present, but they have to be at low enough levels not to cause the death, is kind of the main thing to take away from that. Or there can be drugs present that are not known to cause death, like a medicinal type of drug.
So in this case and on this examination, there was a toxicology report, correct?
Correct.
And what were the findings of this toxicology report?
Well, the main findings, he had a low level of alcohol below the legal limit for driving. His marijuana.
Hey y'all, I'm gonna be on my phone. I'm gonna go stand outside with Son because he's getting ready to leave to go to Missouri. So I'm gonna stand outside with him for a few minutes just to say goodbye to him and stuff. And but I'll be on my phone, okay?
Marijuana level was substantially above the legal
listening.
limit for driving. And he had quite a bit of alcohol in his stomach, but not really very much in his blood, which indicates just that he had drank a significant amount of alcohol just prior to his death before he died.
Let's break that down just a little bit, and let's start with the alcohol, where you just left off, Doctor. Are there different places where these draws are taken in order to arrive at the alcohol content of the body?
Correct. It's very important to, without going into a lot of explanations, to take the blood from a certain region, because that region is more characteristic of the level of whatever drug prior to death. If you take it some other regions, it could actually be higher or lower.
So in this case, was there both a blood draw from perhaps a leg or an ankle and from the stomach?
Yes, they did both of those.
If you could please explain those processes and the findings to the jury.
Well, the blood was taken appropriately, and so I have good confidence in the alcohol level of the blood and the. Have you got a toxicology report, just so
Yes.
I make sure I don't say anything wrong?
I believe, oh, absolutely, and Doctor, I believe it's attached
Part
to
of this?
the back of the report.
So the alcohol and marijuana was done on peripheral blood, which is the appropriate thing. They also took urine and gastric fluid, and they did take heart blood, and they did measure the GHB level in the heart blood rather than the peripheral blood, which is not a good thing to do. It should have been done on the peripheral blood. Those are the main things.
And focusing in on the alcohol content, you had testified that in the blood it was not particularly high, correct?
Correct.
But then you made reference to the alcohol in the stomach. If you could please explain the significance of that. Did that denote recent drinking, heavy drinking? What would that indicate?
Yes, so it was about 30 times higher in the stomach fluid than in the blood. So he had drank, a couple of, some significant alcohol that had not been absorbed yet into his blood.
Now, if the THC content, it was significantly above the legal limit, correct?
Correct, yeah, the legal limit is 2 and his was 26.
So over 10 times the legal limit for
Correct.
THC. So if an individual were to have ingested alcohol, as we have evidence of, and smoked marijuana, could you opine, was that person intoxicated?
Oh, definitely, yes.
If we had heard testimony that this person had gone to sleep or shouldn't be driving, a family member was concerned about him driving, would that be consistent with the findings of this pathological report?
Yes.
In reference to the GHB and the drawing from the heart, you had said that was of concern. If you could please explain why.
Well, because heart blood is notorious for being inaccurate as far as true level of the antemortem prior to death level. I'm not saying it's completely inaccurate, but it would be better to do that on the peripheral blood, which is what the other toxicology was done on, than the heart blood. But even given that, the DHB level wasn't into any significant toxic range.
Turning your attention back to the findings concerning cause of death, manner of death, and specifically the standards of practice, these 5 criteria. Is it fair to say that homicidal violence is an incorrect designation?
Yes.
What should it have been?
The practice standards are clear about this. If those 5 criteria aren't met, then you classify the death as undetermined.
As we've covered cause of death, manner of death, it states homicide. Is that incorrect?
Correct. Yes, it's not correct, no.
What should it have been?
It should also be undetermined.
So based upon the science, the examination of the body, fair to say that this was an inaccurate pathological conclusion, homicidal violence.
Yes.
Finally, I'd like to address there's an issue concerning obviously a missing head. Fair to say that that complicates matters.
Definitely.
And how so?
Well, you know, if you have incomplete remains, it's very risky to make conclusions about something that you haven't examined. You don't really know. Worst case scenario is the head turns up and there's no cause of death with that either. So in this particular situation, that would preclude you from scientifically, objectively assigning a cause or manner of death.
Now, obviously, one of the criteria concerns death under suspicious circumstances.
Correct.
And I don't know if you have had an opportunity to review the file because we haven't discussed it all that much, but obviously we have some fairly suspicious circumstances surrounding this death, correct? And is it fair to say that Dr. Yagi perhaps relied upon that outside the practice standards, but relied upon that in finding a cause of death and a manner of death?
Probably so.
Okay. I mean, we're humans. We make mistakes, fair to say.
Oh, definitely, sure.
In a strictly scientific sense, okay, doctor, and based upon the data, the empirical data, is it possible that this gentleman died of natural causes?
It's definitely possible. That's why you would classify it as undetermined. Before you come to a conclusion, especially one of homicide, which is going to have significant effects, you want to base it on provability. You want to be able to prove it. And in this particular situation, he actually had, in the body that was examined, he actually had causes of death that could cause his death. And the fact that the head is gone precludes you from making a scientific determination.
And again, we've discussed somewhat in this jury's heard for a week and a half, perhaps suspicious circumstances, but from merely the science, he could have died.
Correct.
Natural death.
Correct. The forensic pathologist, that's the role that we're talking about. That's the role I play. You have to base your conclusions on objective evidence, not just suspicion.
Finally, in reference to the decapitation, you obviously reviewed the photos, you reviewed the examination of the body. It was clear that this body was decapitated.
Correct.
Any opinion was it post-mortem? Does he indicate that this happened after death?
Definitely. It was examined by an anthropologist, or an anthropology team, I guess it was, and they concluded that it was a post-mortem decapitation, which I don't disagree with.
Based upon the circumstances, you reviewed the evidence, fair to say it probably happened close in time. time of death, and decapitation?
That's an excellent question. It might be very, very difficult to say that. There's no doubt that the blood was still liquid, but that would be liquid for a number of hours. So it's more likely that it was, but as far as being able to objectively prove it, you'd have to do a substantial number of kind of uncommon tests to do that.
And in reviewing Dr. Yager's report, in fact, she enlisted an anthropologist to do further analysis on C2 and C3, correct? The findings of that anthropologist was that the head was severed using 2 instruments, correct?
Correct.
A handheld knife and a mechanical powered saw.
Correct.
Do you take issue with those findings?
Well, after reviewing all the pictures and looking at them, there was an area in the skin that had, in my experience, the characteristics of a chainsaw. But it was only in an area of the skin, which that would be enough for me to be concerned that was part of what was used.
A chainsaw?
Correct.
So while we have the anthropological findings on the bone, did you view any follow-up evaluation or analysis on the skin that you're referring to?
No.
In reference to this idea concerning the cause, the undetermined cause of death, and we have a post-mortem decapitation, and the time of death, we had agreed that it's fairly close in time. You'd made reference to the blood, and there's been several questions last week asked concerning witnesses and this idea of cast-off. Would you anticipate there having been cast-off given the evidence that you reviewed?
Oh, especially if there was a motorized weapon used, yeah, you would expect substantial cast-off also on the people that, or the person that did it.
So would you expect, based upon your evaluation of the evidence, for that person to be covered with blood?
Well, there would be a lot of blood splatter, yes.
Okay. We had heard testimony concerning, bodies are dissected in the morgue. There's not a great deal of cast-off. We're obviously talking about different circumstances here, correct?
Yes, that would be different circumstances, yes.
Here, we're not talking about a refrigerated body.
Correct.
Here, we're not talking about a specialized instrument that may be used, let's say, in a coroner's office to dissect a body.
Yeah, we don't use chainsaws, but so no, that's a whole different thing. So.
Okay. There had been questions asked concerning the arteries, carotid arteries, and you'll agree with me, the anatomy of the neck is fairly complex in reference to a decapitation.
Yes.
I mean, we have obviously the muscle system, we have the vascular system, we have the spinal cord with all the vertebrae, we've heard are complex and quite strong.
Correct.
We have the thick ligaments, cartilage. Would it be, can you give an opinion as to would it be difficult to effectuate a decapitation?
Oh, yes. Especially if you're just using a handheld knife, would be very, very difficult.
And in this case, we've made reference to a handheld knife and a mechanical powered saw. Again, it's an undertaking.
Correct.
We would expect to see cast-off and blood, correct?
Correct.
Would you expect to find cast-off and blood at the scene where this had occurred?
Wherever it occurred, yes. Unless somebody cleaned it up or something. But yeah, you would do, during using a motorized type thing, you would expect a large amount of blood splatter.
So we're not talking about a morgue, we're talking about perhaps in a bedroom, correct?
Correct, yeah. I've never even considered a morgue anything near a scene of a crime like that.
So that would be inappropriate to make comparisons to what happens in the morgue as opposed to what happens at perhaps the scene of a crime.
Well, I've never done that. I've never heard about that because it's a completely different environment. And so I don't even, there's not even an analogy there, no.
We could have the court's indulgence just one moment. Thank you very much for your testimony, Doctor. I pass the witness.
How are you, Dr. Sims?
I'm okay. How about yourself?
Good. Good to see you, sir.
Not going to disagree with you too much. I just want to clarify a couple things. We're in agreement, sounds like, that it's difficult to determine cause of death when the head is missing, correct?
Yes,
We're in agreement that it's a postmortem decapitation.
yes.
We're in agreement, you weren't at the scene, nobody here was at the scene, well, maybe except one person, right?
That is, yeah, I definitely was not at the scene, no.
Yeah, so you don't know if someone covered it up while they're doing the sawing with the knife or the saw. We can agree there.
That's a good point, and I was not at the scene, nor did I've never visited the scene.
Yeah.
And so, no, I don't know that.
Fair enough. And you mentioned cleanup, goes without saying, you can't say whether the person may have gotten blood on them, took a shower, any of that.
That's correct?
Use chemicals to clean up or anything like that.
That's correct.
Okay. Are you familiar with the term hesitation marks?
Yes.
What does that mean?
So those are primarily in relation to sharp force injury, and they can occur in somebody trying to kill themselves or when they're going to kill somebody else. And it's a mark where you're considering making a cut and you become afraid, or there's some reason that you don't, and so you leave just a superficial injury.
And you mentioned some of the cuts to the back of John's neck.
Correct.
You're not telling this jury that it was, in fact, a chainsaw used, correct?
No, I just talked about one area that was that I picked out, seeing the photographs, that was concerning to me.
Sure. But you'd agree there are hesitation marks?
Definitely.
Looks like somebody who went to do it was like, oh my God, I can't believe I'm doing this kind of thing?
Definitely. There were multiple hesitation marks, yes.
And with regard to the tools, that was sent out to a forensic anthropologist, and there's tool mark experts, et cetera, right?
Correct, yeah, that is a specialized type of analysis, and I thought they did a pretty good job.
Okay, and that was going to be my next question. Are you calling into question Dr. Burns and her associates' work?
No, I read it. They took very good photographs. They made the proper, in my opinion, the proper descriptive statements. So if that report would have came back to me, I would have adopted the report.
Sure. And it's a report. You didn't prepare a report, I've been told, in this case.
No, I didn't. I was never asked to prepare a memorandum or an email or anything about anything. I was just the reason I was originally contacted with this from the Special Public Defenders. They were puzzled about the cause of death. They didn't quite understand it. So.
We are in agreement that the decapitation is not the cause of death.
That is correct.
You would agree with me? We've had cases together before back in the day. You would agree with me that a single blow to the head with a large blunt object can kill a man?
Yes, they can.
And you've probably seen lots of those cases.
Blunt force injury is a common mechanism of death, yes.
And there is a difference between the terms homicide and murder, correct?
Definitely.
Homicide is a medical legal definition, and you know better than me, I think it's death at the hands of another?
Correct. It basically talks about a mechanism. Murder is a legal conclusion, because there can be justified homicides.
Sure.
Or unjust. Murder is an unjustified homicide.
Right, gotcha. My point is you're talking about whether or not it's a homicide. You're taking issue with Dr. Yagi's terminology.
Based on the published practice standards, it did not follow that. I wouldn't have came to this conclusion at all.
Okay, fair enough. And I'm not arguing with you about that. I'm just trying to say, you're not saying to this jury that John was not murdered.
I don't know.
Okay. Murder can be proven by other means, not just your narrow medical legal determination.
Oh, definitely it can. The jury can come to whatever conclusion based on all the data.
Yeah, phones, video, even confessions.
Correct.
Murder and homicide, two different things.
Correct.
Pass the witness. Thank you, sir.
Any follow-up, Mr. Justice?
Yes. Suffice it to say that based upon the evidence available, you could not say this person died of a blow to the head, could you?
No.
That would be reckless.
Yes. There would be no evidentiary basis for that, so I wouldn't say that.
Something I'd like to address on my redirect of you is that we've heard from other witnesses involved in the investigation of this case that this was the first time that they'd investigated, been involved with a case involving a beheading.
Okay.
Have you had experience with beheadings?
Yes.
Multiple?
As far as just in the general term of dismemberment, it's probably around 24 out of my whole career since doing forensic cases starting in 1991. So.
Thank you. Finally, I've got a follow-up question that I'd like to address, and if you don't have any specialized knowledge concerning this, we completely understand, but there's been some discussion of chloramine, the mixing of bleach and ammonia. It was referred to in the autopsy report concerning smoking body, things like that. First of all, can you give testimony concerning chloramine?
No, I don't. That's a criminalist. A criminalist gives testimony about that. I mean, I've definitely been in cases involved in that, and they've talked to me about it. I mean, I can tell you what they told me, but I have an independent. That's not something that I include in my reports or in my estimations, because there's somebody that are better experienced and better knowledgeable than I am.
So you have no opinion as to how long this chloramine may exist? Let's say you put bleach and ammonia together, it's on a body. No time frame, how long that'll be? Nothing. Can't give any testimony concerning that.
No, I mean you can tell that it caused discolorations in the skin from a pathologist's point of view, but I don't have any opinion about that. No.
Thank you, Doctor. I have no further questions.
Any follow-up statements?
No, thank you.
Ladies and gentlemen, the jury have any questions for this witness? Do you write a question on full sheet of paper with your name and your jury number? And Counsel Hirsch? Dr. Sims, if the handheld knife were described to you as a meat cleaver, would it be better to understand that the head could be removed easier than using a knife?
Yes.
Okay. I'm sorry, Mr. Bassett, any follow-up based on the jury?
But in addition to this knife, and again, the findings were of a handheld knife, correct?
Correct.
Would you expect a cut to be different from a handheld knife versus a meat cleaver?
No.
Similar?
Yes.
However, in addition to a blade, based upon the findings, we're to understand that a mechanically powered saw was used.
That is correct. Whether it was a reciprocating saw or a rotary saw or whatever, they didn't go any further than that. But it was some kind of powered instrument.
Thank you. I have no further questions.
State any follow-up based on the jury question?
No, thank you.
Do ladies and gentlemen, any further questions for the witness? Yes, if you write a question, on page sheet of paper with your name and your jury number.
I'm here. I'm back. Good.
Dr. Sims, is it a regular practice for the medical examiner to call in a criminologist when chemicals are used?
It would be, if that is an issue, a recognized issue in the case, it's not some just minor finding, then that is correct, yes.
If alcohol is in the stomach and not absorbed in the bloodstream, does it affect the person's ability to function?
No.
When you talk about natural causes, would you expect to see physical signs of a heart attack or cardiac enzymes?
That's a very excellent question. Because there was no microscopic analysis of the heart, there was no microscopic analysis of the liver to actually fully assess the amount of pathology and whether there was something acute or longer, which should have been done in this particular case.
In terms of the liver, if fatty liver disease progresses, would you expect to see signs of jaundice or bad enzyme levels?
That's also an excellent question. So in his particular case, it had not progressed to cirrhosis as yet, but without getting into a lot of pathology, the storage of fat in the liver disrupts the liver's ability to function, and the function is the main metabolic organ that takes care of all toxins in your body, whether they're drugs or anything else. And so when you lose that, then you allow a higher level of those toxins to be in your bloodstream, which can cause death. That's how it operates.
Mr. Baxter, do you follow up based on the jury?
Yes, just briefly, in reference to the question, the alcohol, based upon your test in the stomach, based upon your evaluation of this person was clearly intoxicated.
Well, the marijuana was really high, and it also worked with whatever little alcohol was present. Both of them are central nervous system depressants. So there's what's called a synergistic effect.
So we would expect then alcohol in conjunction with the THC, this person was pretty loaded.
It was definitely under the influence of marijuana for sure, yes.
Finally, in reference to this cast-off post-mortem, you'd expect under the circumstances of this case for there have been significant cast-off.
If there was a motorized, there can be cast-off even with a handheld knife, depending on how the person is using, but it's going to be very small compared to the cast-off from any kind of motorized cutting instrument.
Thank you. I have no further questions.
Any follow-up statement?
No, thank you.
Do the ladies and gentlemen of the jury have any further questions for this witness? Okay, seeing no response, sir, you are excused. Thank you very much for your testimony here today.
Thank you.
Does the defense have any further witnesses they wish to call?
We have no further witnesses that we are going to call. We are going to arrest. However, we do have a housekeeping matter. Did we get those other exhibits? She's making them right now. Okay.
We'll stipulate to that.
We'll stipulate the defense rests.
Okay, what are the exhibit numbers? E4 through N4 are going to be agenda pursuant to stipulation. The defense will rest at this time. State, do you have any rebuttal?
No, thank you, Your Honor.
All right, ladies and gentlemen of the jury, we have now reached the conclusion of evidence in this case. We have now reached the portion of the case where I'm going to read you the instructions on the law that applies to this case. You guys are the fact finders, so it's very important that you understand what I'm reading to you. So we are going to give you your own packets so you can follow along as I read them to you, just in case I read too fast and we don't want you to miss anything.
Yeah, slow down, lady.
All right, ladies and gentlemen, instruction to the jury. Instruction number 1, members of the jury. It is now my duty as judge to instruct you on the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of this court. Instruction number 2. If in these instructions any rules, directions, or ideas repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point of instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Instruction number 3, a third amended indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of her guilt. In this case, it is charged in a third amended indictment that on or about the 7th day of August 2023, the defendant committed the offense of murder with use of a deadly weapon. Count 1, murder with use of a deadly weapon. Did willfully, unlawfully, feloniously, and with malice aforethought kill Johnathan Willette, a human being, with the use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Johnathan Willette with the said wooden stick or other unknown object, and or through other means, the said killing having been 1, willful, deliberate, premeditated, and or 2, committed during the perpetration or attempted perpetration of a robbery. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Instruction number 4. In this case, the defendant is accused in a third amended indictment alleging an open charge of murder. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. Instruction number 5. Murder is the unlawful killing of a human being with malice aforethought, whether express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Instruction number 6. Malice aforethought means the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise not alone from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed, but may result from an unjustified or unlawful motive or purpose to injure another, which proceeds from a heart fatal event on mischief or with reckless disregard for consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but it denotes rather an unlawful purpose and design in contradistinction to accident and mischance. Instruction number 7. Express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears or when all the circumstances of the killing show an abandoned and malignant heart. Instruction number 8. The prosecution is not required to present direct evidence of a defendant's state of mind as existed during the commission of a crime, and the jury may infer the existence of a particular state of mind from the circumstances disclosed by the evidence. Instruction number 9. Murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first degree murder. Instruction number 10. Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of the killing. Instruction number 11. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. Instruction number 12. A deliberate determination may be arrived at in a short period of time, but in all cases, determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes an intent to kill. Instruction number 13. Premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Instruction number 14. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Instruction number 15. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. Instruction number 16. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time. But a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Instruction number 17. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of a robbery. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule.
Yes.
The intent to perpetrate or attempt to perpetrate a robbery must be proven beyond a reasonable doubt. In order for the felony murder rule.
My favorite sandwich is the bagel with the butter sauce, and I'll come home and put my own ham on the sandwich. And well, of course they put cheese on it, and oh my God, it's the best sandwich in the whole entire world. Real expensive. It's like a $6 sandwich. Even I put my own ham on it, because they don't put ham on it. They put that Canadian bacon and then charge you $5-6 for it. Like a little tiny piece of round Canadian bacon. I'm like, nah, I'm good, peeps.
To apply under the robbery theory, the intent to take the property must be formed prior to the act constituting the killing. Instruction number 18, robbery is the unlawful taking of personal property from the person of another in his presence against his will by means of force or violence or fear of injury immediate or future to his person or property, or the personal property of a member of his family, or of anyone in his company at the time of the robbery. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape of the property. In any case, the degree of force is immaterial if used to compel acquiescence to the taking of or escaping with the property. Such taking constitutes robbery whenever it appears that although the taking was fully completed without the knowledge of the person from whom taken, such knowledge was prevented by the use of force or fear. The value of property or money taken is not an element in the crime of robbery, and it is only necessary that the state prove the taking of some property or money. Instruction number 19, robbery may spread over considerable and varying periods of time. All matters immediately prior to and having direct causal connection with the robbery are deemed so closely connected with it as to be part of the occurrence. Thus, although acts of violence and intimidation preceded the actual taking of the property and may have been primarily intended for another purpose, it is enough to support the charge of robbery when a person takes the property by taking advantage of the terrifying situation she created. Instruction number 20. It is unnecessary to prove both violence and intimidation. If the fact be attended with circumstances of threatening word or gesture, as in common experience, and is likely to create an apprehension of danger and induce a man to part with his property for the safety of his person, it is a robbery. It is not necessary to prove actual fear as the law will presume.
So I'm eating this. Oh my God, these are my favorite. I have to show you. Because I always run low on my sodium. I eat a whole bunch of these. Ever since I had my adrenal gland removed, I don't produce enough sodium. And boy, does it really affect you when you don't have enough salt in your body. Oh my God. We're good.
Instruction number 21, while a verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. Instruction number 22, murder of the second degree is murder with malice aforethought but without the admixture of...
I think someone on the jury complained that she talks too fast and they can't understand her. That's why she said she had to slow down. My God, I don't know why you would want to talk that fast.
Premeditation and deliberation. All murder which is not murder of the first degree is murder of the second degree. Instruction number 23. When it is impossible to commit a particular crime without committing at the same time and by the same conduct another offense of lesser greater degree, the latter is, with respect to the former, a lesser included offense. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, she may, however, be found guilty of any lesser included offense, if the evidence is sufficient to establish her guilt of such lesser offense beyond a reasonable doubt. The offense of murder, which actually charges the defendant with first-degree murder, necessarily includes the lesser offense of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Voluntary manslaughter is a lesser included offense of both first and second-degree murder. Thus, you may only return a verdict of voluntary manslaughter if you first rule out both first and second-degree murder. Instruction number 24. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought and without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. The provocation required for voluntary manslaughter must either consist of a serious and highly provoking injury inflicted upon the person killing, sufficient to excite an irresistible passion in a reasonable person, or an attempt by the person killed to commit a serious personal injury on the person killed. For the sudden violent impulse of passion to be irresistible, resulting in a killing, which is voluntary manslaughter, there must have been an interval between the assault or provocation and the killing sufficient for the voice of reason and humanity to be heard, or if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murdered. The law assigns no fixed period of time for such an interval or leaves its determination to the jury under the facts and circumstances of the case. Instruction number 25. The heat of passion which will reduce a homicide to voluntary manslaughter must be...
She's starting to speed up again, drives me crazy, hurts my brain trying to keep up. Oh, I know. Do you want me to mute it? I can mute it. We can just stay here. And you guys can listen to me chew. Well, she'll read half, and then they'll give their closing arguments, and then she'll read the other half of the instructions. I wonder if they have a time limit for closing arguments. Some of them will take 2 hours. But because everybody in Nevada hates Devyn, and I don't know why. You know, she could be innocent. I think they hate her because of her lifestyle that she chose back when she was younger, before she even had children. You know what? If I could have a body like she did, nice, you know, nice chest area, I'd have probably done the same thing. So, no judgment here. I mean, everybody watches it. Besides me. I did. Okay, we'll finish.
Such an irresistible passion as naturally would be aroused in the mind of an ordinarily reasonable person in the same circumstances. A defendant is not permitted to set up his own standard of conduct and to justify or excuse himself because his passions were aroused unless the circumstances in which he was placed and the facts that confronted him were such as also would have aroused the irresistible passion of the ordinarily reasonable man and likewise situated. The basic inquiry is whether or not at the time of the killing the reason of the accused was obscured or disturbed by passion to such an extent as to cause the ordinarily reasonable person of average disposition to act rashly or without deliberation or reflection, and from such passion rather than from judgment. Instruction number 26. You are instructed that if you find the defendant guilty of murder or voluntary manslaughter, you must also determine whether or not a deadly weapon was used in the commission of this crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting the use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Instruction number 27. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon or device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is rarely capable of causing substantial bodily harm or death. Instruction number 28. The state is not required to have recovered the deadly weapon used in an alleged crime or produced a deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Instruction number 29.
There you go. Oh. Ask and you shall receive. I suppose they're probably going to take their lunch now. It's only 11:40. I don't know. Let me rewind it a little bit and see if she says where they're going.
The internet or using reference materials. 4, making investigation tests. You must carefully describe the testimony to be played back so that the court reporter can arrange her notes. Remember, the court is not at liberty to supplement the evidence. Now you listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by All right, ladies and gentlemen, we do not want to break up the closing arguments for you, so we're going to take our lunch recess now, and then when you guys come back, we will have the closing arguments by the parties.
Okay, so lunch. So I'm pretty sure they'll be back. Oh, man, I probably should have waited to see when the lunch was over. Oh, I'm not.
The parties when you return from the lunch recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, or listen to news or media accounts or commentary about the case. You must not do any research, such as consult dictionary, use the internet, or use the record materials. You must not make an investigation, test the theory of the case, recreate any aspect of the case, or any other way investigate or learn about the case on your own. You must not follow to continue regarding this case that was submitted to you. Ladies and gentlemen, it's 11:40. We'll be in recess until 1 o'clock.
All rise for the jury.
An hour and 20-minute lunch. So 3 o'clock my time. So an hour and 15 minutes they got. Oh, great. So I have to figure out what to do with myself for a whole hour and 15 minutes. So Cindy, if you want to watch something on the boy that unalived his adopted parents, we can watch new stuff on that to get up to date on it. Or we can watch parole. If you're not going to stay, then I'll turn it on the parole channels and I'll watch that. Okay, I just didn't know if you had something else to do or something better to do with your time than sit here and chill with me, because I'm cool. I'm a cool chick. All right, let's find something on that boy and we'll get up to speed. I know, I should put some of my cool sunglasses on. I don't even have cool sunglasses, but that's all right. It's all right. Boy, she's just chit-chatting. I wonder how her kids like her. Oh, the FBI's involved in the Devyn and Celeste. Oh, the mom for Mimi Torres was in court today. Let's see what they had to say about that. Two hours ago. Oh yeah, let's I'm all up on that. Poor little girl.
Hey everyone, I'm News 8 investigative reporter Jeff Dedarian, and today we are going to talk about a case that has captivated the state of Connecticut and has really gone beyond Connecticut, making national headlines. It's the unfortunate story of little 11-year-old Jacqueline Torres Garcia. Her remains were found in New Britain in the beginning of October. There's been a lot of moving pieces with this case, and a lot of people have commented on social media and just said how awful the case is, and we've now got some new information as it relates to new videos, body cam videos that have been released. And joining me today is News 8's Catherine Hauser, who has been involved with this case and covering it and just knows a lot of the details that surround it, because we here at News 8 have been covering it for so long.
And I think there's just such curiosity as to how did this happen? Who were the people involved? You hear of a mother, of a sister, the aunt of Jacqueline Mine Torres Garcia, and also the former boyfriend of the mother too. But you think about impact, right? Parents watching this, wanting to know more, and our job as journalists is that we sort of give the highlights when you see it on broadcast. But this is an opportunity where people who are tuning in can get a deeper dive into the police body camera footage. So exactly what led up to the arrest of these suspects who are facing serious charges in relation to this case, what New Britain police were doing. You've seen the stories, you've all been following this, so this is your opportunity to really pay attention and listen and observe as to what took place leading up to those arrests.
Right, and for people that are joining or watching us, just to give you a little bit of a recap of the story, it was back on October 8th. The remains of little Jacqueline were found outside of a house in New Britain, an abandoned house. Her remains were found in a plastic tote. The medical examiner ruled last week that basically starvation and abuse is how she died. And there's 3 people that are charged, just to kind of go through it really quick. It's the mom, Carla Garcia, who is the mother of Jacqueline. Also the aunt, as Catherine just said, Jacqueline Garcia. And then there's the boyfriend, Johnathan Willette, who had fled and was on the run. Police were able to track him down. And so these 3 people are now charged in connection with the death of Jacqueline. They're charged with a variety of crimes, right? Murder, cruelty, disposal of a body. Each person has different charges, which we'll kind of get into as we go forward. But as Catherine, sorry, go ahead.
Too, no, I think what's so intriguing about this case is the charge that both the mother Carla is facing and her former boyfriend Johnathan is murder with special circumstances.
Right.
And in our case, when that charge happens, it refers to intentional murder committed, and that comes, if found guilty, with the harshest penalty possible, and that's life in prison without the possibility of release or parole. So that is a significant. So when you see those charges against folks, I mean, this is a serious crime.
Yeah, and so just so people know too, the police say that little Jacqueline was starved for weeks at a time. She was held in a corner in one of the apartments that they lived in, tied up with zip ties, not allowed to go to the bathroom. They had pee pads under her. And if all of these allegations are true, which again, these are just allegations, nobody's been found guilty yet, but the details are just horrific. And we should warn you, some of the details here are graphic. And before we kind of start to show you some of these videos, which we're going to try and give you, as Catherine was saying, a real behind the scenes look, sort of take you along with us and with
I know I have to learn to mute. I know I shouldn't talk when I'm playing the video, but if this is hard to listen to or to watch, I can turn it to something else. But these cams, the boyfriend, he got what he had coming. The cops even fist bumped each other. Hopefully they show it. If not, I'll find
investigators, which a lot of this video you'll see, some of it has been edited just for time.
Shout out to News 8 and Investigate for putting this out, and I will share their link in the description box too, as soon as I find it.
Purposes, but a lot of it is raw video, which Catherine said on Channel 8 on News 8, we just don't have the time to show all of this. But in this setting, in the digital extra here at WTNH.com, we are able to do that. So Juliana, our producer, we're going to show you the first video. This is from October 12th, when Carla Garcia and her sister Jacqueline, they're taken into custody, but police are looking for Johnathan Anita. Again, he's the boyfriend of Carla, who is the mother of Jacqueline. A little bit hard to kind of keep track of. You need a scorecard maybe with all the names, but this is the first video now we're going to show you. We go inside their apartment as police and detectives look to take the two women into custody, and they're still searching for Johnathan, the boyfriend. They had not found him yet. Juliana, let's go ahead and roll that.
They came and got the dogs? All right, so he's not here at all? We can check, right?
Is Jacqueline here? Your sister's here? Where is she? Okay.
Jonathan, are you in here? Is he in?
Johnathan, come out.
He's not in here? Is he in here?
No, we haven't seen her.
Okay. How you doing, Jacqueline?
I'm good. How are you? Oh, wait. Same
It's
person.
me, yeah.
Yeah.
Turn around.
Why?
Put your hands behind your back, you're under arrest.
For what? Hard.
We'll explain to you. We'll explain that
Can
in a
you grab
second.
my phone?
Yeah, we can grab your phone for you.
It's in the room.
Here.
No, not that one.
I appreciate you being cooperative, okay? Let me,
I'm just wondering.
I'll explain everything. Good? You comfortable here? Whoops. Is that okay for right now?
Why are they being so nice? Who cares? They hurt a little girl. A little girl is unalived because of these people. Ooh, makes me angry.
You got anything on you?
No.
No?
But can you please just grab my phone?
Yeah, where is it?
It's
That's
in the
right.
room.
Which one's that?
This one.
So here, Catherine, we can just, we'll talk over this a little bit. So detectives now are sort of making their way through the apartment, and they've now told the aunt that she's under arrest. So just listen in here really quick.
Yeah, that one.
Carla's here too, the mother.
Thank you.
I think also important to note is you hear the aunt when she's put in handcuffs, she asks why, for what?
Right.
And then asks a little more, but then gets quiet in that moment, and then she is seated, and you see Carla, the mother, she also has handcuffs.
Right. So they're now both being placed under arrest. Again, the aunt is sitting there, and Carla has just been put in handcuffs.
Yeah, on
She came that night?
Hell yeah, she was.
Did she bring it back to the
Yeah, she did.
She brought the puppies back?
Yeah.
All right. You got shoes on, right?
Yeah.
Okay.
And so they're making sure that, again, these women have shoes on. If you look a little bit to the left, Catherine, right, you can see that Carla, the mom, they're getting a sweatshirt for her. Might have been a little bit cold that night.
Yeah, where is it at?
Wait, where's my black sweater?
Again, detectives looking for things, possible evidence collection.
I mean, and there's a number of officers, as you can see in the background during this arrest. If I just count, you see at least 6 to 7 officers in their apartment at the time.
Jacqueline,
you
where
see
would it
some kids bedding, you see their beds, and you
Well,
get
it's not
an
in here
inside
other than the
look
closet.
into their home.
Right.
I have some in my. Oh wait, check if it's on my sister's pillow.
And so the dates, just so everybody can kind of keep track, this is October 12th. Jacqueline's remains were found October 8th in New Britain. So here they are in one of the bedrooms. Again, body cam. This is all
just give you this
official
red one?
body cam video.
Is this all right?
No.
What do you mean no? What do you mean no? Now you're being picky.
No, I'm kidding. Just put it over me.
Yeah.
What do you want to like put it over your head?
And you know what's crazy is the little girl looks just like that. Just looks just like her aunt. Yep. Isn't that terrible? And named after her. I can't wait for this one to go to court.
Put it over my head. I don't want nobody to see me.
I don't want anybody to see me. That's what she just said.
Did you let Joe know?
So before they were arrested, Carla was at the police station because they were rioting outside her apartment. And she's like, I don't feel safe. She says, I can't go home. They're trying to ill me.
Again, the officers from this videotape, right, Catherine, very accommodating, trying to make sure that they're warm. And, you know, again, they're filming all of this. This is all actual body cam. If you look to the right, you can see the time code going on. This is as it's happening. Again, we're taking you inside the arrest of the two women.
Interestingly, the mother, Carla, you don't see her say much in these interactions. You see the aunt speaking with officers.
Yeah, we'll adjust them when we get up there. You're going to go into a warm car anyway. So, we got heat in the car.
And they're talking through the logistics of getting them to the car at this point.
Right. So what's happening here is they're getting ready to, as Catherine's saying, bring them downstairs, put them in separate cruisers, bring them to the police station for processing, fingerprinting, etc.
I'm going to hold your arm walking down.
They still haven't said exactly why they're being arrested, what the charges are.
Yeah, because I don't want you to go. You got nothing.
Careful, yeah.
Yeah, they are being let out now.
Yeah, just go slow when we get to the stairs.
Go slow.
Soon enough. Next week.
And this is what happens when somebody's taken into custody. This is obviously details are different in every case, but this is what happens. There's a large police presence here, detectives and also uniformed officers, and they appear to be cooperating. So there's no issue with restraints or use of force or anything like that. It's not necessary, but these officers are ready if that were to happen. Believe me,
and it
they
is
are ready.
Interesting too. These two women, these sisters, as they're being brought to these police cruisers. This is a much different interaction, and you're going to find out this later than what police had when they arrested the boyfriend, Johnathan and Anita.
Right. Very good point. Much different sort of scenario.
But you don't hear. I mean, you heard. Jacqueline say why, what for, but you do not hear that out of Carla's mouth.
Right. And we also have some video that we'll show a little bit later of Carla, the mom, Carla Garcia, when she's at the police station, and she had not been placed under arrest. It was earlier in October. It was actually the day when they had found the remains of Jacqueline. And you'll be interested to hear what she has to say once we get to that. So there you go. That's that video there, Catherine. They're looking for Anita, the boyfriend. They haven't found him yet. It's sort of a manhunt going on. They go to this apartment. Carla's there, the mother, Garcia. Jacqueline, the aunt. They're taken into custody. They're not really told exactly what the charges are or what the circumstances are. They cooperate from everything we've seen. But again, that's just raw video that we've obtained from the body cam of this case. And next we will show you the arrest of Johnathan and Anita when he is confronted by police and what happens. We'll tell you about that in just a minute. This is a digital extra on WTNH.com. Catherine Hauser's with me. I'm Jeff Dadarian. We'll be right back. Hey there, guys. We're back with our digital extra. We're covering the case of Jacqueline Torres Garcia, the 11-year-old girl whose remains were found in a plastic bin. Catherine Hauser's joining me. There's a lot of interest in this case.
Yeah, I was just going to mention that there has been so much public interest, and when that happens, I think it's our job as journalists to give you all of the information that we're getting in real time too. And you can also observe and see exactly how these arrests are happening. You can also speak to what are the suspects doing? What are they saying? What is their body language? What is their interaction with police as well? With the boyfriend, and you hinted at this at the start of the show, was that there was a search that was happening because investigators could not find him. So in the days after Jacqueline's remains were found, there was this search for him that was happening. And there's a series of events that lead up to his arrest on October the 13th. And I was thinking about this. The case, I mean, this all broke October 8th, and here we are, almost mid-November, and so much has happened in a little bit of time. All three of these suspects are going to be in court later this week.
Again, this is video that's in essence unedited. We've edited some clips just to be fully transparent because of timing, but this is video that's just running for minutes and minutes at a time. But let me stop talking and let's go to October 13th. This is when police were able to arrest Johnathan and Anita in connection with the murder of little Mimi Garcia. Juliana, let's go ahead and show people this video.
Oh, give me your hands! Get him! Oh, I'm dead! I'm down! Go! Got a gun? No. Got his hand, got his hand. Get your hands! Give me your hands! Give us your hands! Hold on.
Okay, he's got it.
Hold on.
We got one leg stuck.
Okay.
No, hold on.
Cuffs?
My face!
Hold on. Move
My
this.
face!
Pull him out. Pull him
My
out.
face!
Hold on. Put him in cuffs. Put him in cuffs first.
My face!
I know.
My face!
Hold on. Fight.
My face! I can't feel my face. I'm bleeding.
Hold on.
What's your name?
Johnathan.
Johnathan what?
Nanita.
No, it's not. What is it?
Johnathan Anita. It's Johnathan Anita, I swear.
He's complaining. Okay.
Want to pull him out? Pull him out. Hey, drag him to you. Drag him to you.
One.
Go to me. Sit up.
Yeah, I'll call this special now. Just use that.
So just for a little context here, Nanita resisted arrest when they tried to apprehend him. So he was apparently on the ground and may have gotten some scratches or some bruising or something on his face. Later, they call for medical attention to make sure that he's okay. But clearly here you can see this is how the arrest was made. And we listen in here. He says he was going to turn himself in.
Dude, y'all beat me up.
Didn't beat you up.
Yes, y'all did, bro. Listen, bro, you'll get checked out. Don't you worry about it. Come on, bro. Y'all didn't have to do that, though. I was going to turn myself in. Y'all didn't have to do that. Turn yourself in. You guys didn't have to do any of that.
You turned yourself in a while ago.
I was gonna say I was. You guys didn't have to do any of that, man. I didn't even do that to that girl, bro. I didn't. I'm over here trying to clear my name. You'll have your time to talk, buddy.
That was a big interaction and moment between police and Johnathan Anita, and his arrest followed earlier in the day. There was an incident at Big Sky Gym in New Britain. Police apprehended some of his friends, according to the warrant, in a stolen Hyundai Palisade. And according to that warrant, they appeared to be breaking into parked cars, and then there was news of a connection to Nanita and that he was spotted in Waterbury and they had a vehicle description. So this is what you're watching, is that interaction taking place in Waterbury.
Right.
Yeah, it's your time.
Today's your time.
Yeah, I think it's 9:21. Now you can turn yourself in.
So there you hear the officer say, now it's today's the day you can turn yourself in. You need to telling cops a minute ago that he was going to turn himself in. He apparently did not do that, but now said he was going to turn himself in.
Two of our cars. Cool. Oh, you took our phones earlier.
I didn't smash on that. I left.
If you were going to turn yourself in, why didn't you stop in New Britain?
Stop right when you guys came?
In New Britain, in Big Sky.
Almost hit 5 people.
When you guys came?
Yeah, when we came.
When you drove off in New Britain.
I drove off, but I didn't hit you.
Why didn't you stop and turn yourself in then?
You're calling on people driving out of the way and
You're already right in New Britain. I got a bird for you.
Can we throw him in the
I
car?
didn't do that, man. I'm innocent.
Oh, you got it. We go.
My head hurts, man. I didn't have to do any of that. We'll get you medical.
It is interesting hearing how he said he was going to turn himself in, yet there's ultimately this pursuit that happens.
Right. And it was, and he resisted when they did. It's important to point out where you had mentioned that the arrest of Carla Garcia and Jacqueline Garcia, the mother and the aunt, in the apartment that we showed just a couple of minutes ago, that was without incident. There were no issues. There was no scuffle. There was no on the ground. But he's hiding under the car. He's trying to, clearly was trying to get away from them. And they did have a medic come and check him out. And so, he's charged with murder and improper disposal of a body, and other charges as well. So he's the mother, Carla and Nanita. They are both facing the murder charge, as you know.
That's right. And I think as so many people have wanted to know more about this case, they wanted to see these folks who are facing these charges. This is your window into police interaction with them And as reporters, we get the opportunity where we can get this information, these records. We have to sift through them. You yourself have been through so many different pages of documents,
Right.
and when you're putting them, on TV and reporting them, we can't really show all of them. We can show portions of it. So
Correct.
this is a unique opportunity for folks to get a real window, like you said.
Yeah, I mean, this is how an arrest happens. This is actual body cam footage. If you look there, you can see the time code and the date and the timestamp. This is the actual video from the detectives and from the officers, and there's close to 24 of them that we've reviewed. I reviewed and watched every one of them. Like Catherine, as she does her stories, we take the time and do it. And again, we can't put all of it on TV just because of timing. But in this setting, in the digital extra setting here at WTNH.com, you can kind of see this again. We're taking you along for the ride here as investigators make this arrest. And this was October 13th. Again, just a quick recap. October 8th, little Jacqueline's remains were found outside of that house in New Britain. And police, detectives, undercover cops, they're doing their work as days go on. Sometimes people will come up to me and be like, well, why does it take so long? Why didn't they arrest him quicker? And, listen, I'm not here to speak for the police, but they basically, are putting things together, right? Following leads, chasing things down, and these things, take time. It's not like watching SVU where in 60 minutes it gets all solved, right? So I think that's important to point out. So here we see he's now being processed, right, Catherine? He's being, he's going to be put in the back of a car and taken to the police station, and again, processed, fingerprinted as well. And he has not, he said that he had nothing to do, I'm paraphrasing, nothing to do with what happened to that little girl.
Yeah, he does. He says, I'm innocent.
Yeah.
I had nothing to do with what happened to her, as you can hear quite clearly in that video. I was thinking too back to October 8th when this case first broke. It all started because of a 911 call. Somebody saw suspicious activity happening outside of that abandoned home on Clark Street. That's a place that you have been to several times, where there was a growing memorial, this outpouring for Mimi, for Jacqueline Torres Garcia. This case has captured our state. I think for anybody who's a parent, anyone who heard really these graphic details, disturbing details that have been sifted out through these warrants, we've learned that in the weeks leading up to her death, according to the warrant, that Jacqueline was tied up with zip ties, that she was starved, and also the cause of death that we also learned too, and her remains found in a plastic storage bin behind, again, that vacant house that has that growing memorial.
And when we come back, we'll show you video of Carla Garcia at the police station. What does she say? May surprise you. We'll be right back. Hey everyone, I'm News 8 investigative reporter Jeff Dedarian. I'm here with News 8's Catherine Hauser, who you can see every day, obviously, on News 8. And we're talking about the Jacqueline Torres Garcia case. We've kind of unpacked, we've kind of peeled some of the layers back. So now we're going to take you to the police station. It's October 8th. It's the day that Mimi's remains were found. Carla Garcia not under arrest. They're just talking to her. But take a listen in terms of what she had to say. Let's roll the tape.
Carla Rosalie Garcia?
Garcia. I just wanted to talk to you quickly because I hit Barcelona. They call me JB.
You've been here for a minute, I know.
I've been here for a minute. You're good. I wasn't out there, so I hear that it was kind of like a hostile situation, and maybe you wanted to get out of there to a safer place. Does that sound right? All right. As of right now, you are not under arrest. We brought you here to get you out of that dangerous situation and bring you somewhere safe.
I'm not safe.
Well, I'm saying right now you are.
But if I leave here, I'm not safe.
Right, I understand what you're saying, but you're not under arrest.
And I don't want to go because I'm not going to be safe.
Okay, you don't have to leave here, but
You want them to kill me?
I just want to make you aware that you're not under arrest.
I know I'm not under arrest because I didn't do nothing, officer.
Exactly, okay. I just want to make it clear.
I'm being honest with you.
Okay, thank you.
Because if I did, I would tell you. I really don't care. I'm ready for anything.
We would like to talk to you.
I'm ready to talk.
Okay, good. So just hold on for like 2 seconds, then we're going to get you right out of the box.
But you better go get them.
Okay, you're going to get names, okay, and then we'll figure it out.
Yeah, I will, because if them come with me with guns again,
Yeah.
I have kids.
Oh, you're worried about the kids now.
Yeah, we'd like him to bring.
Listen, where I dropped my kids off, that's where they went.
Okay.
If something happens to my kids, I'm gonna really have a anxiety attack.
Where's your kids now? To what house?
It's a White Street.
157 Dwight.
Yes.
Do you think this cop really thinks she really cares about her children? When one of her children is not here because of her? Come on, lady. Get out there in that street and get what you got coming to you.
That's where they all are?
That's the Addy. Because I remember.
I just put it out over the air to have someone go check.
Okay. How many kids are over there?
5.
5 kids?
I have 5 kids.
We're going to go ahead and let the community take care of her. No, you have 6 kids. 6. Did you forget about Jacqueline Mimi?
5 kids. All ages? How's the oldest? Who's the oldest?
12.
12.
Because Nina is 11, I think.
Who's 12?
Jackie.
So it's Jackie, Nina, and then who?
Juliet, Major, Annie.
Annie, how old's Annie?
She turned 9 months today.
Oh, 9 months. So between 9 months and 12 years old are your 5 kids?
God bless you. I only have 2 and it's a lot. You got a lot going on. We're going to talk to you, all right?
I'm depressed.
Sorry to hear everything. You got a lot going on. Sorry.
I don't want nothing happen to my kids for I didn't do.
Of course. You already know what you want to
I already died.
She doesn't have her phone on her right now.
Could you find my phone?
Yeah, we'll look for it. Well, because we want to get you somebody down here for support.
I need to talk to. I need my sister.
What's her name?
Jacqueline.
Jacqueline what?
I'm her sponsor. They everything up.
Your sister lives on Kelsey Street?
No, she lives with me. And
Oh, okay.
No, they everything up.
On Fairview?
What's gonna happen to my sister? She's on parole.
On Dwight?
No, she's not Tremont with me. When I
Was your sister there?
Yes. And they were trying to attack her. You seen it.
Yeah, I got our whole shift out there, okay?
Yeah, the whole shift's out there.
They literally.
So there you have when Carla Garcia, the mom of Jacqueline, was at the police station October 8th. She's referencing a group of people. She says she's afraid, etc., paraphrasing. And that's when word had started to get out that Mimi...
All right, well, we all seen their court dates. But do you guys... Cindy, are you back? Before I start talking about this next thing? Or Kathy, you here? Anybody here? Okay, well, I'll turn it on the paroles until I see that you're back.
Good morning. The Committee on Parole is called to order. Today is November 13, 2025. The time is 9:02 a.m. My name is Cheryl Renatza, serving as chairman of today's parole panel. And, on the panel this morning, my colleagues here in Baton Rouge is Ms. Carolyn Stapleton. Joining us remotely by Zoom is Mrs. Jerry Ledoux. We are at DOC headquarters in Baton Rouge, so I'd like to ask the staff here to please introduce yourself for the record. Carl Williams.
Francis Abbott.
And our first remote location this morning is at Claiborne Detention Center. And I believe we have Mr. Como before us.
Yes, ma'am.
Mr. Como, would you introduce yourself? Tell us your name and DOC number.
My name is Reverend James Como. My DLC number is 441810.
All right, Mr. Como. Let me acknowledge the guests that we have here who are here in support. And their sisters, three sisters, Tessa Como, Andrea Como, and Katrina Como. And so we'll ask for their comments shortly. First, I'm going to read some identifiers into the record, and then I'll ask you if that information is true and correct. And then I'm going to turn it over to Mrs. Ledoux because your case has been assigned to her this morning. You ready?
Yes, ma'am.
So, Mr. Como, you're classified as a second felony offender. You're currently serving an 18-year sentence. You were sentenced in Acadia Parish in January of 2011 for one count of indecent behavior with a juvenile, and your parole eligibility date was November 30th of 2018. You don't earn good time, so your full-term release date is November 29 of 2027. Is that information correct?
Yes, ma'am.
All right, Mrs. Ledoux?
Yes, good morning. Mr. Como, have you served 15 of your 18-year sentence?
Yes, ma'am. I'm coming up on 16 years.
Coming up on 16. And I was a little confused reading your report regarding the classes you've taken. I saw where you had started phase 1 and 2 of the sex offender treatment, but were you removed for disciplinary reasons? And have you ever completed that course?
I was removed because where I was taking the class at, a table had got destroyed, and my name, I was written up for it, but they couldn't provide footage proving that I did that, so they just kicked me out the classroom and never reinstated me. You know, and those write-ups were dismissed.
And so have you requested to be...
Yes, ma'am, I have requested. Yes, ma'am, I have requested right after I was kicked out of the class. You know, I asked to be reinstated, and they had transferred me over here.
And they don't offer that at the facility that you're in, correct?
No, ma'am.
Okay. So you have one count in this particular case. Was this an isolated incident, or because I have the record, just to be honest, was this an isolated incident?
Yes, ma'am.
Okay. I don't see in your file any transition plan to return to society. So what were your thoughts about that? Because I know you have to have an approved residence plan for the particular crime that you're on. So what are your thoughts on that?
Well, my family, my three sisters that support me, you know, they have housing that they have did research on that I will be able to go to. Plus, prior to my incarceration, you know, I was in the transportation industry,
And, I would like to go back to that, but, I understand I might have to start at the bottom, and work my way back up, but for the most part, I've learned a lot on this, during my incarceration, what it is to be resilient, what it is to have discipline and be patient, no matter what trials and tribulations I may face and go through. It's not what I go through, it's about how I respond to.
So I didn't delve real deeply into your disciplinary conduct because you have been right up free for the last 3 years. But how many DBs do you have in your jacket?
I don't have none that I'm aware of because I've been over here at this facility for going on 5 years in January and I haven't received a write-up.
Okay. Are there any members of the staff there who could speak about, so what is your job currently?
I don't have a job at this facility and, it's just...
They don't have anything for y'all to do. It's just doing time?
Yeah, it's just doing time. I mean, they do have trustees in their positions and stuff like that, but, I guess I don't, I'm not with the politics, it's political.
Okay. So you never took pre-release for substance abuse?
No, man, when I was in Allen Parish Correctional Center, I was taking NA and AA and stuff like that, but that was in like 2015 and 16, but I got transferred from there.
Okay. I'd like to hear from your sisters at this time. Who wants to go first?
Okay, not everyone at once.
Which one? Yeah. Okay.
I can go first. I'm sorry, I had some issues unmuting my phone. Good morning. My name is Tessa. I'm Merlin's younger sister. And actually, I have actually been doing research. I spoke with a couple of people. There's 2 homes in where we live. There's one in Lafayette called Sober Living. There's also another one in New Iberia that houses strictly sex offenders. I've been in very close contact with both of them. They're both waiting for me to respond after this hearing. We have a bed already ready. I've looked into the programs. I've also spoke with Miss Ethel, who has an outreach program here in Lafayette that I'm sure you guys are familiar with. The homes that I've spoken with, they are fully vetted with the Louisiana Board of Pardon and Parole. So they both said that he would qualify. They were looking into some more information. Miss Ethel Thibodeau with Beacon Connections, it's a community outreach. She's prepared to help with sex offender fees, housing. We have a lot of resources. My other sister who's actually on the phone, she works for a similar program, a day program, and she also has a lot of resources. So we've gotten information on just like curfew, the programs, different things that's offered in these homes, different type of support groups. There's also one in Lafayette called Sober Living where they have to go to church and they have to receive therapy so many times a week. They have to find a job. So I have a lot of information that I can send over to you guys if you would like. But we've definitely been looking into things and just trying to help him to transition back into society because I know it's going to be a challenge being that he's been in there for a while. But we're willing to help however we can.
Okay, great. Thank you very much.
Yes, ma'am.
And the next person, which other sister wants to speak?
I'll go. I'm Chandrea Como, ma'am. How you doing?
Good.
Well, I'm his younger sister, and I have a CDL license. My brother also, he held a CDL license before he went in. And we looked into the process of getting his fee. A lot of fees have been waived because he's incarcerated. So I think now his balance to get his license back is like $800. They're just waiting for him to get back to go to the DMV to get on a payment plan. And I have jobs, like I have a lot of connections with jobs to get him back rolling. You know, I know he can't go like far out. He got to stay like in the city or whatever. But I have a lot of connections with jobs. They just need him to get out to fill the application out. We have a lot of connections. People are willing to help him.
Okay, right. And the last sister. Sorry, I don't have a name in front of me.
Hi, good morning. My name is Quatrina Como, and I thank you for allowing me the opportunity to speak on behalf of my brother Merlin. I just want to say that my brother has been in court for years, and during that time, he has reflected deeply on the choices that led him there. Through these years, I've seen a real change in him, not just his words, but in his attitude and the way he carries himself. He's grown in faith, humility, and gratitude, and he truly understands the seriousness of his past and has taken full responsibility for his actions. The man he is today, not the same man who entered the system all those years ago. My brother often speaks about wanting a second chance, not only to rebuild his life, but to also be a positive influence on others. He hopes to use his story and his experiences to teach other young men who may be heading down the wrong path and to help them understand that every decision matters and that redemption is always possible through accountability and change. He is committed to becoming a productive member of society, to work, to give back, to live a life of integrity, and all he is asking for is the opportunity to show that the lessons he's learned were not in vain, and that no matter what mistakes a person has made, it's never too late to change. As his family, we will continue to support and encourage him as he takes the next steps in his journey. I know he can't change the past, but I also know that he's truly remorseful and he's ready to move forward in a positive and a meaningful way. I thank you for your time and for considering his request for parole.
Thank you. Well, I would say, Mr. Como, that you are extremely blessed to have the sisters you have. And they have spoken very positively about you, but I want to hear from you. What have you learned during this time about your behavior that sent you to prison? And I mean, we've read all the details. So you tell me, what have you learned?
I have learned that, what it is to, live a life on life's terms, Prior to my incarceration, I was abusing, cocaine, and, I was making choices, that led me here, and I understand that, and as I got older, I got wiser, and, rehabilitation, a lot of these places, they don't offer it, but it really starts within. You have to take accountability and responsibility for your actions, and nobody's perfect. We all have our flaws, but I understand what it is to be a man. I understand what it is to go through things and how to respond to it, and I really learned my lesson and things like that. I'm not a violent individual, I'm not a career criminal or anything, and, I'm willing to do whatever it takes, to reintegrate back into society and to be that member, to take care of my family and my loved ones that has been there for me for all these years.
Yeah, well, talk to me about about the impact on your victim. I mean, that's one thing I haven't heard any of your sisters talk about, or you. I want to know what you've come to understand about the victim impact.
What I come to understand is that the victim, has suffered, mental anguish. And since then, the victim, we have, put our differences aside and, forgiveness, I was forgiven and things of that nature. And, I'm really, remorseful and sorry for my actions, my crime and everything. And I understand that, what I did, was not right.
How not right? How not right?
It wasn't right by the laws of the land,
It's not right morally either. It's not right as a father. It's not right. Okay. I'm going to allow my colleagues to ask some questions. I want to reserve to be able to come back. But if my colleagues would like to ask some questions.
Yeah, I mean, I follow along the same path as Miss Ledoux. When she asked you the questions about what do you think about your victim, you talked only about yourself and that you're forgiven and all of this kind of stuff. But I don't think you have a clue what that must have done to that child at all. So even all these years later, I don't think you've reflected on how bad what you did was. So I just, that's all I have to say about it. I don't see any changes there.
I'm sorry, ma'am. Is it okay for me?
No, ma'am. No, ma'am. I'm sorry. Mr. Como, you've been before the parole board twice. You were denied both times in 2018, 2021, and the reason stated each of those times was the need for sex offender treatment, because at that time you hadn't had it. So you've had phase 1 and 2, right?
I took phase 1, 2, and 3, and I went to came up for parole in 2023, and they said I had victim opposition, which was untrue.
Right, I did say there's no victim opposition today, but your record that I have only shows phase 1 and 2.
No, ma'am, I took phase 1, 2, and 3, and I was testing out. I was at the end, and
You must not have got credit for 3 if that's when all that stuff with the table happened. Maybe they didn't give you credit for 3. Do you have contact with your daughter or her mother?
Yes, ma'am. My daughter, she wrote me a letter, and she told me, she needed me, to be in her life. Yes, I am in contact with her.
And do you, well, that's all I have for now. Ms. Ledoux, you want to follow up?
Obviously, Mr. Como, you have to have pre-release prior to release. That is just one of the requirements that the state has put into place. And that has not, do they have pre-release where you are?
No, ma'am.
Okay. And there's some things that are missing in the puzzle piece. I think that with the completion of your sex offender treatment and your pre-release, then that gives me the confidence knowing that that's been completed. And the support that you have from your family, obviously they've worked very hard to come up with that. Let me tell you one of the things that, the way I think about this is that you're going to be off paper in 2027. And if you are released in 2026, you will have time on supervision. The Department of Correction will be able to supervise you and know how you're reintegrating. Does that make sense?
Yes, ma'am.
Have you been on supervision before?
I was on probation. This was way back in like 2000 to 2001.
Yeah, but you have to understand this is going to be a very intense supervision. Okay, with no option if you ever got out before your full term date. I'm prepared to vote. I'm going to vote to grant your parole conditioned upon completion of the sex offender treatment and pre-release with approved plans and with increased substance abuse testing and a curfew. I want to have this period of supervision so that, because you have no victim opposition. There's no opposition to your release. You obviously have support. Your evidence-based evaluations are good. So I think that this period of supervision with some additional, would be helpful from my mind. So that's my vote today.
All right, thank you. Mrs. Stapleton? Well, I agree with everything Ms. Ledoux said. I mean, she's put on some very good conditions, and that would be necessary because you are fixing to get out. It was not a long time. So that would ensure that you would continue your treatment plan. And so I concur with Ms. Ledoux.
All right, Mr. Como, I do agree. We need, documentation that you complete the sex offender treatment. We'll send you back probably to buy you door cheats so you can finish that program. Do you understand the other conditions that Ms. Ledoux laid out?
Yes, ma'am. It's just the pre-release. Will I have to take that over there too, or I'll be transferred somewhere else?
They have it. I think they have it there.
Okay, so y'all gonna make sure that I get transferred to these facilities because it's nothing that I can do on my own.
I know, but we can get that done.
I would like to add that I think you only should have supervised contact with the victim while you're on paper. I think that needs to be a supervised contact so that we understand and you understand that that's you're not to be alone with the victim until you're off paper.
Yes, ma'am.
All right, so, well, you got a little bit of work to do, Mr. Como. But you can go. What's
Do you understand how? Do you know like how long will it take, like for me to be transferred over there?
Well, we're just going to make the request to DOC, and we don't have any particular sense of how long it'll take. But usually they do it as quickly as a bed is available. So good luck to you. That concludes our business there at Claimer.
Well, I guess he gets another chance as soon as he does all his stuff. They're still on lunch for 20 more minutes.
All right, good morning. The Committee on Parole is convening now at Ouachita Parish Correctional Center. And we have before us Ms. Gay. Is that you?
Yes, ma'am.
Would you, for the record, introduce yourself, tell us your name and your DOC number?
Melissa Gay, 612-179.
Right, yes, ma'am, that's what I have. And let's see, we have with us today in support, we have your brother Raymond Blunt and your daughter Lacey Barber, both of whom want to speak for you. We do have opposition. We have from the 21st Judicial District Attorney's Office, we have Tatlin Costa, Alexis Taylor, Michelle Sparks, and Tamika White. And we'll hear from their spokesman also shortly. First, let me read some identifying information into the record, and then I'm going to turn it over to Mrs. Stapleton, seated here to my right, because your case has been assigned to her today. You ready?
Yes, ma'am.
Okay. So, Ms. Gay, you are classified as a third felony offender. You're currently serving a 10-year sentence. You were sentenced in Livingston Parish in February 2024 for possession of buprenorphine and possession with intent to distribute methamphetamine. You received 10 years on both of those convictions, but it's running together. It's running concurrently. You have a parole eligibility date, which is March 10th of 2026, and your mandatory release date, good time date, is March 10 of 2027. Is that accurate?
Yes, ma'am, it is.
Okay, thank you. Mrs. Stapleton.
Yes, ma'am. Have you served? Is 2 years of the 10 years that you were sentenced? Is that how much you served so far?
Yes, ma'am.
Okay. Why don't you tell us why you think you should be paroled early? and tell us how you got here today.
Well, I'm gonna start by how I got here. I started making a lot of bad decisions, and of course, I'm not proud of the things that I've done, but it took that to lead to where I am today. I'm just, I'm not saying it was right for what I've done. I know that what I've done, it isn't right, but it took the time that I have been incarcerated to change my way of thinking, and I wouldn't have been able to change that had I been at home. It took this time to change the way that I'm thinking now, so I'm appreciative for that.
How do you think now?
I'm ready to, I've been working for a year now. Before I came to jail, I wasn't thinking about how I wanted to take care of myself and work and be productive. And now I want to go home and work, and I want to be the mother that I can be to my two girls, because I'm very blessed to have the family that I have that's behind me. And I'm ready to show them what I'm capable of, what I know I've been capable of all these years. I just haven't put forth the initiative to be that person.
What type of work would that be?
I want to work with the disabled or the elderly. That's my passion.
When did you discover that was your passion?
It's always been a passion of mine, but I've never put forth the initiative to make it official. I've done it with friends or with family around the house, but I've never really made a living off of it before, and that's something that I really want to do.
Do they have a work release program where you're located at?
I'm in work release now. I've been here for a year.
Okay, and tell me what you do there.
I work at a baby factory. I'm a line lead. We produce baby medicines and box it and ship it out.
That's good. So you've been, how long you been there? I think I know. But
January the 6th is when I came here November the 14th, but I didn't actually start work till January 6th, but I love where I work.
Well, that's good. That's really glad to hear that. So I guess what we'll do now, I did want to ask you about your programs. What kind of programs have you taken?
I've taken some online programs, substance abuse, domestic violence. That was something that I needed to take from my past. Parenting, life skills.
They don't offer any classes there? You have to do it online?
No, ma'am. They offer them, but you have to be 6 months short of your time in order to get into them. So online was the only way that I could go.
Okay, I understand.
Yes, ma'am.
All right. Well, why don't we hear your supporters, what they have to say? Who would like to go first? Well, is there anybody there from the facility who would like to speak? Or is it just you in the room?
It's just me.
Okay. Mr. Blunt or Ms. Barber, would you like to speak? Tell us what you have to say.
I'll speak.
Okay.
Well, as she says, she has had issues, but during this time, she's not asked for anything. And as far as the caretaker, she does help take care of our grandmother that is 80-something years old. And me personally, I was in a bad motorcycle wreck about a year before she went to jail. And I was bedridden and in a wheelchair, and she used to come sit beside my bed, take care of everything I needed, whether it was water or anything. And she did lose her way. And she knew she did because she talks to me all the time on the phone about it. And she just wants to get out and do better. I don't even want to say she wants to get out and do better. She wants to do better right now. She's even told me that she needed what she has gotten, as hard as that is for anybody. As anybody, she says she knows she needed to be removed from the dynamic she was in because she wasn't strong enough to get herself out of it. And I believe in her, and we're very frank with one another. And I wouldn't be here today if I didn't believe in her. You know, I'd be willing to bet anything on her. She is a good person. She has done things that she shouldn't have. She does love her daughters. She loves her brother. And we need her, but we need her to need herself. And I believe that's where she's at. She doesn't complain, none. Not a single time she's been in there and she called me. As a matter of fact, I have to fuss at her for not calling me enough. But she said she don't want to bother us because she put herself there, but she's not bothering us. We love her and we want her better, but we want her to get better and then come home. And I think she is better, and we're ready.
I understand that. It's wonderful. I'm glad she has your support. Lacey, would you like to speak?
Yes, ma'am. I just wanted to come in here today to show my support for her position. There's been a lot of things that she's done in the past, but I feel like one of her biggest downfalls has been her heart, because she lacked the ability to say no whenever somebody requested help. And a lot of other people knew that. And anytime that she would go out of her way in order to help, it would backfire. She's put herself in positions to where her sole responsibility, regardless of whatever else was going on in her life, to care for the elderly. She's sat, I can't even tell you how many people's bedsides she sat beside and taking care of them whenever most other people complained and said that they had other things to do. It would have been really hard if she wasn't there during the times that she was in order to help with, like, my grandfather. Before we didn't really have the best relationship, but during her incarceration here, she's reached out and she's made.
I don't know, but I have to say this, but it looks like Miss Tamika White, she looks like she's intoxicated or something, or she's fallen asleep or something. Something's going on with her. I mean, she don't look right. Maybe something's wrong, like she's sick or something. She keeps like she's falling over.
Efforts that I haven't previously,
in my opinion,
seen, and like, it just meant a lot to me, and it shows that she's trying to better herself. She does have a long way to come. Not everybody changes in, just a couple of years, but the amount of change that she has displayed since being able to contribute to, like, working, which she wasn't able to do previously, it's an outstanding improvement. I will say that. I feel like she could make a positive change in not only her family's life, and I think that she would bring a positive aspect to, like, the workforce as well. This is the first time in a while that she's had that opportunity, and it's changed something.
Well, I'm glad that you've had this opportunity to feel good about your mother. I mean, you need that for yourself. And it's wonderful that she is in the transitional work program, because it does give her an ability to have some self-esteem. And I know that's what you want for your mother. So she's lucky to have you for a daughter.
I've been feeling lucky to have her lately.
There you go. Thank you for your words, okay? All right. Ms. Gay, we have some opposition, so we're going to hear from them. It was read out to you from the 21st JDC. So Alexis Taylor, would you like to speak, please?
Good morning to the board. So yes, the state is opposed to an early release. And one of the things the board mentioned here is the fact that she is a triple offender. So she has avoided a substantial amount of time in jail because the state did not invoke the habitual offender bill. Additionally, she's received 2 years, 2 concurrent sentences when they could have been consecutive. And not only that, considering her criminal history, it dates back to at least 2010, where there's an arrest for operating a clandestine lab. Now, that charge was ultimately dismissed, but we do have a 2013 and a 2020 possession of Schedule II convictions that both resulted in probation. And in spite of those opportunities on probation, where she had all the time and opportunity to make the improvements that she's telling us she's going to make here today, she did not. And she continued her activities. The facts of this particular matter include her distributing drugs to another party and her making an admission doing so. So while I appreciate, that she feels as though she is ready to be released and make positive contributions, the state does not feel as though she is fully prepared for that at this time, and we do stand opposed to her early release.
Okay, thank you very much, Ms. Taylor.
Thanks, Alexis.
Let me ask you something, Ms. Gay. We have a parole eligibility worksheet, and part of it does talk about a pre-release programming and a substance abuse, but like you said, you can only get it online. Do y'all have pre-release programming there?
No, ma'am.
No, you don't have that.
No, ma'am.
Okay, and of course, the ADA just went over the facts of the crime, that you did have paraphernalia and you did have methamphetamines, and Suboxone, which you sold, and then you still had some at your house. And then concerning to me also was the past that you did have previous charges that were very severe, and you did have previous probation, so you had other opportunities to get back on track with your life. And you haven't done it, so I know for a fact, I think any family that can say there's nobody that they love in their family that hasn't been touched by drugs or mental illness, yay you, because the vast majority of the population can't say that. So this is in no way, shedding unkind light on you, because this is something that is a long-term problem. We know that. And you need long-term help for it. So I'm going to pass it along to my board members to see if they have some more things they would like to add. Mr. J.
I don't have any questions or comments at this time.
Thank you. So you mentioned, how did you first get it, started, I guess, with your drug use?
My daughter's father committed suicide, and when he did, I lost everything, including where I was at in my life. That was the start of everything. Whenever I lost him, because I loved him, we were together for 10 years before he committed suicide, and that's where it all started for me, when I lost him, and I lost everything.
What year was that? What year was that?
2005, I believe.
So that's when you started your drug use?
Yes, ma'am.
You also mentioned that you took domestic violence. That was one of your online courses you mentioned, and you mentioned because I needed it. Can you explain that?
After his death, I got into a bunch of relationships because I felt like I had to have a relationship. in order to be okay with myself, and they were not good. They resulted in me in the hospital, and I still kept going back because I wanted to be loved, and I felt like that was the only thing I wanted. I had to have somebody, and so I believed that the domestic violence was needed for me, which is why I chose that.
Well, and you know, I too am concerned about, I appreciate you sharing that with us, by the way. I am concerned about your substance abuse treatment. As you said, it was you lost your way. It's been a real problem for you.
Yes.
And for me, I think that's critical that you get some kind of treatment, not just education, but real treatment, so that you have tools to cope with life in general. I realize that you do like you love your job.
Mm-hmm.
And I'm sure you do a very good job there. It's because they've kept you for as long as they have. But, for me, I'd like to see you get some substance abuse treatment. So I think that I don't think there's any other questions. Are you prepared to vote?
No, that would be mine, that she has to have a transfer for substance abuse treatment.
Yeah. So I think we're ready to vote, Ms. Gay.
Ms. Gay, today, I think you have wonderful support from your family, and they want to see you succeed, but you need the tools, just like Ms. Renata was talking.
Oh my God.
With a wooden stick and or an unknown object by striking the said Johnathan Willette with the said wooden stick and or other unknown object and or through other unknown means. The said killing having been 1, willful, deliberate, and premeditated, and or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Johnathan Willette with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Johnathan Willette. Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required.
Welcome back.
To have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to delivery. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond a reasonable doubt, we're able then to eliminate guilty of first degree without, use of a deadly weapon, and also guilty of second-degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice aforethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice aforethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice aforethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Johnathan a back massage while he was laying face down on his bed. She was next to him. She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes the conscious decision to then walk over, goes to the bed, and while Johnathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you that there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard. The killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Johnathan Willette, had blood on her leg. And then she kind of just shoot it off. It was like, okay. And then, after that, he seemed happy, right? His face was turned away, he thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon. Because no one's going to get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. And sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car and I'm not going to have coffee at work if I slam on my brakes? is my purse gonna fly off the seat, and I'm already running late for work, so how am I gonna have time to put all the items back in my purse so I can walk into work? If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time to fire. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm gonna have to go through this light. But what are you thinking about when you're going, making a decision to run that yellow light that's about to turn red? You're hoping there's no cop, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. You hope there's no bicyclist that's just somehow hoping that you're going to stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case. When the defendant made each conscious decision ending Johnathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1. Obtain or retain possession of the property, 2. To prevent or overcome resistance to the taking of the property, or 3. To facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Johnathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How was she going to enroll the girls at school without having Johnathan's documentation? This all goes into her motive. The defendant obtained Johnathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devyn, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devyn did not murder his father. Let's go through that. We'll start with Devyn's testimony under oath. He tells you that he saw his father, Johnathan Willette, at that Porcupine Rim address, the house that he and Devyn shared. Briefly on August 6th, you'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devyn's daughters, with homework. The defendant, Devyn, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls, around 2 a.m. to see Devyn getting in bed, which they shared at that time, and he just went back to sleep. He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work. Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devyn told you. This is a text message that Devyn sent to the defendant, Devyn Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room." Corroborating that he put the girls to sleep and he was going to sleep as well. This was on August 6th, 2023 at 10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devyn's vehicles in Paladura's neighborhood. Paladura being the murder house neighborhood. No vehicles belonging to Devyn are seen. And we spent a lot of time going through that video surveillance on that lengthier day of trial, showing you that there is no indication that Devyn's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devyn's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devyn. Remember that fixed camera? There was no indication that his vehicles left that evening, or entered, for that matter. Devyn's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devyn's van, remaining in the same position, to a T. There's also no video surveillance showing Devyn jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devyn leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devyn out, beyond his word. If you recall, there was that Detective Good testified pretty in depth. He had color-coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devyn's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night. And more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down. At no point do we see Devyn at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right-hand corner, we see the victim's truck, Johnathan Willette's truck. We also see right next to it, Devyn's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devyn's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Forensics also ruled Devier out. A lot of discussion about how he jumped a back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devier and the defendant's relationship, Devyn's relationship. Devyn is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devyn Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devier to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devier do? He moves back to Las Vegas. He doesn't want a kid at his young age. And even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devyn was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be W, let's talk about who's on trial today. Devyn Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony, Devyn's inconsistent statements, so her own words, the scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devyn, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devyn arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devyn, the defendant, and John drive to Devyn's home. At 9:40 p.m., Devyn and John drive back toward the murder home. 10:04 p.m., Devyn and John they get to Chevron. They're there for a few minutes, as we saw. And then return back to the Palo Duro neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devyn and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devyn's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera. But more importantly, closer to the house, right in front of the driveway, and nose to nose with Johnathan's truck which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devyn for about 15 minutes or so. At 2:04 a.m., Devyn leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Johnathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devyn committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devyn at the murder house. And more importantly, he also saw her vehicle at Aladura. We heard from Yoko. Again, around 8 p.m., Devyn arrives at Aladura in her Nissan Armada. Devyn and John then leave in John's truck. Around 10 p.m., Devyn and John return to Aladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devyn, and what did she describe to you? Devyn looks surprised. Why?
Absolutely, she's guilty. She admitted she hit him over the head. But the problem is who did the head part? This poor guy in his head. That was just bad luck. Okay, I just had to cut in for fair use. I don't want to get in trouble. All right. Do you see how he puts his screen down so nobody can see it? We can't see it anyways.
Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around back to see the bed. But regardless, she sees that the light is on in the room. Devyn tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devyn talked and washed dishes for about 15 minutes. Because that's when Devyn told her that Johnathan the next morning was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devyn, and the victim, Johnathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devyn. Around 2 a.m., she wakes to the dogs barking in the backyard, and if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devyn had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up. Prepares her coffee, goes back upstairs. She called him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him, because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees the doggy door is down and the dogs are still outside. Abnormal. She saw inside the garage door inside the garage door was half open, the one leading into the garage. Abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there. Abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devyn also made several inconsistent statements. The truth is the truth, it should change. What were those inconsistent statements? The first one, Johnathan's engagement ring. If you recall in interview 1, Devyn tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2. Threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2.
That's one thing I've noticed about Asians is they love their trash cans. I think they'd have one every 5 inches if they could.
3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2. Her marriage to Devyn. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3. Her marriage to Devyn is just on paper. Rings aren't significant. Me and Dev haven't been intimate in years.
And that's none of your
true.
business.
Inconsistency 3. The gun safe. In interview number 1, Devyn tells officers, we took the guns last night, but we didn't bring ammunition because there's no safe at my home for them.
Cindy, that's awesome. I'm so happy your friend is doing that. I know when you only have 2 people, it's hard to cook, I always end up making buttloads of food for Son and I. I've always, because I worked in daycares and I was always the cook, because when Amy was little, I was a breastfeeder. I breastfed Amy till she was 4. And they told me that she couldn't go to preschool unless I stopped feeding her, on the boob. And I said, oh no. I said, you guys hiring? Dude, I got a job working in the kitchen there just so I could feed Amy. But it became to the point where she thought I was the drive-through. She thought she could just lift my shirt up at any given moment. And I finally had to say, oh, I think we done here. But I didn't care, you know, but it was time. It was time for the separation.
Ladies and gentlemen, you saw pictures of a safe.
Yes. I loved it. I loved feeding Amy. I loved it. Yes. I loved it. Oh yeah. So they go deer hunting? I've been deer hunting a lot. My dad was a hunter, fisherman, everything. Oh, my dad could do anything under the sun. All right, let's do this.
There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Johnathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday. He leaves stuff around a lot. Minimizing. Then we have interview number 3, which is after the search warrant of Porky.
I even ended up tandem nursing my first 2 because they were 13 months apart. Oh, wow. Wow. It's nice, you know? It's just the most beautiful thing to be able to feed your child. But I'll keep this moving so we're not here all day. But Cindy, can you resend me your email? For some reason, my phone didn't save the photo because I didn't have any memory, but I do now. I bought some with Son's money. Can you send it again so I can email you my my email? Okay.
Behind Rim, where they start to confront her with the fact that there's Johnathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Johnathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license you found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one? I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview with Detective Weinoff, that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devyn told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at
The email sent, Cindy.
Devyn's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devyn committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know,
why
John
are
was
we
home
assuming?
and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen?
The lady in the last trial that I watched was assuming. Assuming. Why? We must never assume. Come with the facts, lady, or don't come at all.
That's because the phone...
Devyn could probably teach you a little bit about that. Yeah, she probably could.
Wasn't left by John. You know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devyn's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Johnathan.
Oh, excuse me, I'm so sorry.
She tells them, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to figure out, trying to solve this case for the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after. You heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Johnathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Johnathan. Why? She's told, this has got to be eating you up. And this is why videos are so important. This is her response.
This is definitely eating you up. This is definitely eating you up.
She's nodding.
This is definitely eating you up.
This is eating her up.
This is definitely eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Johnathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Okay, Cindy.
Well, you have to have something for the outer 4 minutes for it to be murdered. That you were in the house. That's it. That's the only time you don't remember.
I didn't know you said that long.
It doesn't matter if you know.
I don't remember being with them. I didn't know that.
Okay, so the possibly you did it, you don't remember?
Yes, sir. It is very possible.
Okay.
Yes, sir. It's very possible.
Well, at least she wasn't lying.
The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on this bed, and there was blanketing. And we also noticed that there were 2 blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devyn drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Johnathan's cell phone was found at Devyn's house during that search warrant of the Porcupine Run residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Johnathan's blood. It's also important to note that Johnathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Johnathan's bed frame, where they saw those droplets of blood. All Johnathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devyn would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devyn's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devyn's DNA. This wasn't Johnathan dropping it in a bag. Why would Devyn's DNA be inside the wallet? Devyn and John's DNA are on his Social Security card swab. Not shocking that Johnathan's DNA is on his Social Security swab, or Social Security card, I should say. But remember, this is Devyn's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that Social Security card belonging to Johnathan Willette. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Yagi.
I got your emails, Cindy. I'm gonna, can I put them on my community wall? And then I'm gonna post them on Facebook also, because I have a really big following on Facebook. And I have a big following on TikTok. And is that okay or no?
Cause of death, homicidal violence, the manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Johnathan was decapitated by the defendant after she bashed him with the stick.
Prove it! You didn't prove that!
Based on the science. No one's disputed that. Not even Dr. Sims today.
No! Ooh!
This is also important. No bleeding injuries on John's hands were found. None.
Show me his hand so I can show you where it is.
She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Casts, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Johnathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burla. Where was Devyn's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burla, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Johnathan. Then we have 2:04 a.m. This is when Devyn's Nissan Armada leaves. And we saw that in the burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back at evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phone during all of this? More importantly, where was Devyn's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, but there's sort of this blue dot that is now traveling with Devyn's red device all the way back. And this was at that 2:04 in the morning. So that's how we know that the victim's phone was taken by Devyn back to her home, because we have that Google geofence highlighted by that blue dot there of Johnathan's phone, showing when it actually got to Porcupine Rim, and that's when Devyn got there. We also heard phone content evidence, which demonstrates Devyn's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Johnathan says. I want our family back. We got to do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Paladura neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts here. Then we have that next door residence to the murder house, that 2696 Paladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Paladura. We also see in this vantage point of the video when Devyn and the victim returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devyn and Johnathan, getting out of his truck to go inside of the Paladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Johnathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Paladura neighborhood, they're arriving into that neighborhood around 10:12 p.m. All corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-through, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devyn. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera from Devyn's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devyn's Armada and Devyn returning back to her residence. At no point was Devyn or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devyn's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Johnathan had been given full primary physical custody of the two girls, Tamaya and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Johnathan technically still had full physical custody of the girls. He had something he could hold over Devyn's head. The walls were closing in on her.
You know, I don't believe that. I don't believe he was holding that over her head. She had the girls all the time. I mean, at this point, why would it matter? I mean, she had the girls, she put them in school, where she lived, all that. So why is that such a big deal? This lady, I don't like her. And I don't like the way she puts her hands down and moves her hands. And I just don't like anything about her.
We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devyn was arrested. She meets with Devyn on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you the girls are being placed somewhere else because you're not there and their father is no longer around. And what Elizabeth Lemons Woods testified to is that Defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devyn appeared that she was trying to cry. Why would you try to cry? Devyn said during the same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming. It's hard, and Mr. Giordani hit the nail on the head when he said, buckle up, this is a wild ride. This is unfathomable. But this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
All right, ladies and gentlemen, we need a moment to set up the technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication.
I was behind a little. I thought maybe they were doing it already, but I guess not. Holy schmack rolls. So are they just taking a whole 10 minutes or what? They make it hard for me to live life. What's wrong, Leah? Huh? Oh, I guess I should, being we're on a little break. Don't forget to like, share, and subscribe. Thank you for being here. I appreciate it. And if you're on the replay crew, don't forget to like, share, and subscribe also. And thank you so much for taking the time to watch my live. I need to figure out how to edit. I know how to edit, but I don't know how to edit videos through StreamYard yet. I suppose I could probably watch some videos on it to take all this extra, not the commentary, but like the parole stuff and all that. I need to figure it out. I wonder if they'll start debating today. Or if they'll, maybe Monday they'll start. What time is it? It's 2:00. They might. You never know. Trying to think of what time Son left. Maybe I can go back and look. Because I know it's a 10-hour drive. I have a question. Do you guys think we'll get that $2,000 stimulus? I know nobody's here to tell me, but I don't know. I kind of think we will. Oh yeah, I was looking for a message of me saying what time Son left. He's going to Anderson, Missouri. It's like a 10-hour ride, 10-hour drive. Man, I hated that ride. Oh God. Oh, don't tell me what time I sent it. Darn it. It was before their lunch. I don't know. I want to say maybe 3 hours he's been gone. I do have to go out there and move his cousin's car. He left me his cousin's car so they could drive my car, our car, to Davenport so it can sit there over the weekend. I said, take anything out of it because people will look through windows and bust windows for $4. Davenport is a horror. The Quad Cities is a horrible, horrible crime. That's where Amy lives, but she lives on a good side of town, though. I'm in a group, and there's a lady named Kelly. She's from Davenport. Well, how long did they need? She said just a short break while they did the equipment. I mean, come on now. Even I could do that in shorter time. Ah, here we are. Oh, where'd she go?
All rise for the jury.
Please be seated. Your Honor, the jury is all present and accounted for.
We are going to go back on the record and see 377239 State Development versus Devyn Michaels. Wait, the record reflect that Ms. Michaels is present with her attorneys. Deputy District Attorneys on behalf of the state. We both parties speaking in the presence of our jury.
Yes, sir.
Yes, Your Honor.
Okay, Mr. Justice, are you prepared for your closing argument?
Yes, Your Honor. Thank
Whenever
you.
you're ready.
Thank you. This case is entitled The State of Nevada versus Devyn.
See, and then the lawyers want to talk all
Proof
low.
beyond a reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state, and the state alone, to prove its case, each and every element of its case, beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devyn Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states, murder with use of a deadly weapon. Did willfully and lawfully, feloniously, with malice aforethought, kill Johnathan Willette, a human being, with use of a deadly weapon, to wit, a wooden stick and or other unknown object, by striking the said Johnathan Willette with said wooden stick and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or, of all things, committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devyn has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of the facts. You will review these instructions. But unlike us, who had this case for some time, this case is new to you. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There's a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Devyn in mind.
You know what I noticed? Unless it's somewhere where we can't see it, but there's no clock. They don't have a clock, like the digital clock that's in all the other courtrooms.
You know, we started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. You know, this case is not going to be well Did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Devyn committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make as the sole judgment of the facts is whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. If state fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps...
Welcome back, Cindy.
Perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. I mean, hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada.
Welcome back, Kathy. I didn't know you were gone. Cindy tells me when she's leaving. You just leave for hours. But welcome back. Welcome back, Otter.
I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. I mean, we've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19.5 years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with the decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about the industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that, in conjunction with this high level of THC, would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devier's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippisch and the other detectives show that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence, and I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense, but it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Talavera residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence. at 2:04. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do, but we had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippish testified several times that he could only speak to items that he canvassed for, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of the forensic examiner O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the 3 videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3. I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture, and that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these 3. And again, this is at the residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devyn had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood, which the continuous camera doesn't show a vehicle, there's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Johnathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies.
Hi, Sandy. How are you? Hi. Sorry, I was just over here playing my game, listening. I hope you're feeling good. If anyone's in here, if I can get prayers for Sandy. She's having some health issues right now. So prayers would be good for her. And keep her in your thoughts, please. Thank you.
She's letting you know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question, the state claims that Devyn was answering Johnathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. Those notifications wouldn't have shown up. That evidence, like so many other pieces of evidence, were mishandled. But the state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department.
Thank you, Cindy. Hey, Cindy, check my Facebook and see if you can send the request. I opened it up. I just want to close it back up.
Documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. When you look at the photo, you can see that they're fresh. They wanted to argue that they're male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Devier's. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. And there it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night. This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Johnathan. You recall, Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene, and Dr. Sims took issue with this. She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue. Bodies that have been refrigerated, but nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English. It was important to memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devyn at 1 a.m. and Devyn didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devyn when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Johnathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devyn made to the detectives. There is no blood visible on Devyn's shirt at the CVS drive-thru pharmacy. Thank God that she stopped there. Because again, we have real time. We have real evidence that shows that she didn't commit this crime and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly, and again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated. She's murdered and decapitated Johnathan. She's making sure that she picks up her daughter's medications on her way home. There was a very good question that was asked concerning, was there any stops? There wasn't. Her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bombs and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. The state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? If she did. The car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herbs. Again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippisch that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th, and we didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. She gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Johnathan's room was a mess. And there's this kind of a feigning of not understanding, and I said, "Man, these are your own words." And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. When she spoke to police, and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time than it would be now. But again, you know, there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devyn's statements about chairs, about a struggle. Johnathan was killed after she left. What's kind of weird is that there were 2 belts tied together on the ground near the bed. There's been no explanation by the state, and we can't give you one, but something's going on in here. Crime scene GPS. Devyn's car is trackable. We know that she didn't stop. You know, she was there that night, and that's why she was charged. Her phone is trackable, clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herbs. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. You know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Johnathan had a union. You know, the state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that, the flip side, a 19-year-old. You know, when we talk about motive, what drives a person to murder, is it not passion of a young man? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. You know, it's kind of an archetype, you know, the father that's killed by his son. I mean, it's...
Kathy says, the defense lawyer is too much. Yeah, I would have to say. Cindy, I agree, Kathy. They showed a bed with all over it, right next to the headless, you know what. So yes, there's a lot of, you know what. Yes. Hi, Cindy, and thanks. Thanks, Cindy. 2 belts tied together, spanky, spanky. Oh yeah. I bet you she was a wild one. I wish you were a wild one. Yes, I know a lot of songs. A lot of songs roll through my head. Today when I was at Walmart, I was singing to myself, at the Holiday Inn. Okay, we'll just go on. Just never mind what I just did.
It's in, I believe it's Isaiah 38:18. We've got these Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn, It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement, because we didn't know where it was going to go with Devyn, but we knew that they'd had a relationship that had been kept clandestine. Devyn covered for Devyn, and Devyn covered for Devyn. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58, there's a 44-second call to Devyn from her phone. You recall, we get the text, and you want to talk about an alibi.
Well, thank you, Sandy. I'm glad you came in. I'm glad you came in and said hi. So excited. Okay, I'm going to play this so we can get this over with so I can lay down for the rest of the day. You know, I'm home all alone. And we'll be till Sunday, man. I'm going to chill. Chill. Okay, here we go.
Type text, putting the girls to sleep. It's 10:36, I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devyn was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, and understandably so in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, we knew the night before that Devyn had been there late with Johnathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devyn's phone to Devyn. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped, or what we saw there was Devyn leaving, we don't know. States to provide that to you, the timeline. They haven't done that due to the slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling deep. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devyn's statement and reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Johnathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication. Again, no blood, gloves, chemical smell, any of that on Devyn. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lena's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target, because they're going to take what you say and they're going to twist it. Yoko was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. And I think we had the prosecutor bang his hand. She'd never talked about that before. but still, may have happened. 2:04, Devyn's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and it's silly to say a murder didn't occur, obviously it did. It happened after Devyn left. The facts, taken as a whole, bear that out. Again, you heard, and it's uncontroverted, Devyn leaves at 2:04. What's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is if she was awake during this whole time. Where's the testimony of a mechanically powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Johnathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devyn had with him. It's a person that's enraged. I watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause for someone to do that? There's been a great deal of argument made and points attempted to be scored that Devyn did that because she'd do anything to get her kids. It was uncontroverted that regardless of what was going on with the family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Johnathan was moving in. There was talk of marriage. And they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And no, why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring, there was no notations, and they'd go through hundreds of crime scenes. When they were there, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devyn's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation, because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devyn Michaels. I'm going to focus on the third interview.
And then, have you guys ever had a sexual relationship?
Yeah, we had.
Okay. But it's not there now?
No, I can't even have sex now.
This is important. This isn't something that Devyn is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
any reason why John's blood or anything DNA related would be in your vehicle? Because up to the back to our station, our CSA, they're going to thoroughly look for everything in that vehicle.
I couldn't tell you if he was bleeding from when he was doing the thing. He helped load up the truck, so if he was bleeding, it was like,
Or your Armada.
my Armada. Like, he was putting the things in the car, like anything else he had.
There's going to be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if you find any DNA evidence in that vehicle, obviously we want to make sure we asked you if there would be a reason.
No, the only thing I knew he said was his hand that he had on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
Okay. But you didn't see that?
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. For the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, was it very clean inside? And I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Johnathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. You're taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. Miss Miriam didn't, but there's the table that she talked about. It was a moving day. Injuries do happen. We're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injuries. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devyn is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in her driveway. A more reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone. Whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Johnathan. She knew he wasn't dead because she didn't kill him. Another thing, there was a big point of contention. Sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not. She couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven his case. Devyn's isn't. It was handled. Maybe there weren't epithelial cells left from Devyn, Clearly, Devyn took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him, or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. That she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. You have to ask yourself what went on. What happened before this interview?
John? This is Johnathan in that song?
Yeah, but he had his boxers on.
Okay, he had his boxers on.
I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on.
That's what I'm talking about. The shit's getting real. Keep looking at that. Take another look at this.
This was into the interview, and it's a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously, that day, about the decapitation. So there's more going on. She knew. It's at 16:01, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devyn Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word, and he's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos, and he filled in those details. And she's sitting there, having been arrested previous to this interview, and facing the horror of being accused of a crime, a murder, that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you have been stuff where...
Yes. There's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
Okay, you don't have to tell me if you don't want to, but what is wrong with you that you say that
I don't know. They're testing me now. I think yesterday, for whatever reason, my brain tingles and then I black out. And I literally have on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. Your patient established her patient she feels like tingling, vibrating in the back of head, comes and goes, denies headache, has dizziness. This isn't some ploy. She's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives. It's confirmed.
Absolutely. You're going to that and everything. You can have the audacity to give them closure. Shame on terrible enough. Get out of here, I'm sure the other day. Also, there's there's anger now, huh? I told you from the beginning I did. Is that how you feel against him? No! There's nothing I could have done.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. What you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stops. Image of Devyn and Devier. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position, well, this is just randomly popping up. Devyn had said that he was asleep, or Devier had said that he was asleep at this time. He testified under oath. He lied under oath. Look. There's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those are all after 11 o'clock. We have no proof where Devier is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devyn. 3 of them were the girls. What about the other 8? But of all images, at 2:12:38 a.m., this is being looked at on Devier's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos, he was a gamer, they had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file, there's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there, and again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up, and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not one indication, but two. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this discord, we have a remnant that he's on and at, it's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis, with only 3%, we were able to show he was awake. This was deleted, it's there. I'm not saying that was that night, but that's something that should be taken into account, headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker.
Oh my God, Cindy, I'm so sorry. Yep, she should have taken, oh yeah, she should have taken that plea deal. Sorry, I was doing my playlists, I was working on my videos. I have so many videos. But after I get monetized, I'm gonna get rid of some of them that are like really old. And I didn't know what I was doing. But Cindy, I'm sorry about your friend's nephew. Not the nephew, but your friend. And yes, Cindy, she should have taken that plea deal. And this guy is like, literally, I'm like trying to keep my eyes open. But Leah's got to go out. So I'm going to do that real quick. So sorry, got sidetracked. My mind was somewhere else. All right, sorry. And was that in Florida, Cindy? Is that like, can I look up the case?
He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devyn. You know, you see on the crime TV shows about motive, means, and opportunity. He had all three. He had the motive. He had the means. He didn't walk there, but he was talking to somebody. Clearly, he had the opportunity given the timeline, but again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. If what I can know, I can't fuck with you. Boy, that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devyn did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devyn. But Devyn's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's a way to get out the back. There's no cameras that were pulled on Rebecca We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devyn. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun. There's guns in his possession. We don't know if that person was shot or not. Johnathan was. The swords, again, we're not trying to throw these things out, aha, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked, things that I missed. Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things. She didn't commit this murder. She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
I think are you prepared to give your rebuttal argument? Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality now. I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about in jury selection. They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake, that woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. Because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Devyn sure didn't do it, and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskevich just got up here at the very end and he told you those two things, you know, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him, probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me? That guy was murdered. And then his head was chopped off. And here's the elephant in the room. I don't care if you for some reason believe Devyn somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over. This is the beyond reasonable doubt instruction. Mr. Draskovich addressed it. I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. So a question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskovich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devyn did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devyn, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Ms. Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having a past. Doesn't matter. The only reason that does matter is because it dictates that relationship with Devyn a little bit, colors it. She is an experienced woman, much older than Devyn. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, he had left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no texts, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devyn was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devyn was doing. He was knocked out, probably passed out, if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devyn had got up and snuck out, because we know the one little girl is awake and panicking and like scared and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devyn left us? Like, really, Mom, where are you? Of course there would. Of course there would be. And there isn't. That's because Devyn was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There's zero evidence that Devyn is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Ms. Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay? Think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devier's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devier did this? A single piece? Other than speculation and really good questions by a really polished defense attorney? There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devier for this homicide. Because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovic just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, they left out a text that's right after that, where dad is reaching out to Devier like months later saying, hey. This wasn't some big, rift, homicidal relationship between dad and son. Now, when you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Lina and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide, specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer or try to answer a couple of unanswered questions for you. We all get this evidence before trial. We're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence when we come into this case. There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked Dr. Sims those questions earlier. I didn't challenge his credentials. Like I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you? That there were other bleeding injuries on the body, including the hand, right?
It's those quiet ones you have to be worried about. It's what I always remember to myself. Always watch out for the quiet ones. They're the ones that will get you. Yep, my daddy taught me that. 'Cause I'm Forrest Gump. No, just kidding. Man, I crashed hard, man. I had a lot of coffee and I was about to crash. Ooh.
Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at.
Well, I'm not going to rule him out because they said that whoever did it would have been full of the red stuff and they would have had to have taken a shower, but she never changed her clothes. But I don't think he's all innocent either. I think he should have been investigated more. No, I believe that she unalived him. Of course. But I think he played his part.
DNA profiles. And DNA is in every single cell of your body, including your blood. And so, no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually.
Okay.
Because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body, except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to have. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. How could someone be capable of doing that? That question, I can't answer. Okay. This is reality. It happened.
You know, I don't carry my phone everywhere I go. My phone could be lost in the car and I take the whole day to find it. I just sit inside and my car would be out in the phone. Or my phone would be out in the car. Maybe he dropped his phone in her car and when she got home and she was taking the girl's stuff out, it fell out of the car. Yeah, I know. Good point, right? Yeah.
I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskevich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded, but he walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth. He got up here. He testified. He looked at his wife. He looked at all of you, he looked at me, he looked at the marshal with the gun and the badge, and he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple times because he's a witness. But you got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger to you, and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and he answered questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? His testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He has some inconsistencies. We don't shy away from that. He's not perfect. I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means. He's not a criminal mastermind. No disrespect to Devyn, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskevich brought this up, so I just have to address it. So you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they crushed it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskevich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So, when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way and she was going to make some changes and live the life that she wanted to live. So it is by law a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charge. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit. I just want to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Miss Griffith showed in her closing. John is continually saying, I miss my girls, I miss my girls, I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Miss Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying we need to do this, we need to have them under the same roof, she doesn't respond. So go look at those when you're thinking about motive and tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you the evidence says is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devyn. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out already? That's because no one expected John to try to make the move that night. And that's when the wall started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devyn woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devyn. It's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So He said, and he showed you the video, there's no blood on the defendant in that drive-through. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not arguing to you or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it. Mr. Draskevich asked you a question and I need to provide an answer. He said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah. That's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any possible way. And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There's two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation.
Okay, Cindy, have a good night. Thanks for being here. Don't forget to hit the like button if you haven't done it. Oh, shoot. I'm calling Kathy. Sorry, Kathy. I didn't mean to call you. Jesus. Sorry. Okay, back on. We got to finish this, man. I'm getting tired over here.
As I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff. And legitimately, in her mind, he was still alive after she hit him. Because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is. I have to mention the timing of the big confession, not the one to
Oh my God, please be done.
the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskevich, this is the defendant covering up for Debbie here. If that is true, why does she confess after she's arrested? Right? She's already been arrested. Debbie has gotten away with it. Why does she confess after?
Well, why would she do it before?
It's what happened. Mr. Draskevich showed a couple of videos, the small movement off screen. Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement, when it goes off screen. And we know that for a fact because the burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the burglar, so just needed to clarify that. Want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails. Devyn was home. Devyn was asleep. That's it. Need to briefly address this DNA stuff. So Mr. Raskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devyn's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home, of course her DNA is on the sword. If John's DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely nothing. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times different witnesses talked about it being trash day. It is not very hard to walk over 2 homes or 3 homes and dump a bag or basket or whatever it is in a trash can. And, I got to address the investigation. Now, the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient shortest distance between 2 lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested. too important to miss anything, so bear with me. I know it's getting late. Almost. Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse that goes, admit what you can't deny, deny what you can't admit. I'll say it again. Admit what you can't deny, deny what you can't admit.
Dude, get on with it.
I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly be? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Ms. Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying, to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest. This is real stuff. Okay? Real stuff. Do not think about whether you think she deserves a little leniency or redemption or this is a one-off. She lost it. None of that matters for you.
They better check and make sure the jury still has a pulse.
That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please.
Not if you don't shut up for 5 seconds. I'm just kidding. He can talk all he wants.
Please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide. Thank you for your time and attention these 2 weeks. We really appreciate it.
Oh, good Lord. Hallelujah.
I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
Yes, I do.
All right, ladies and gentlemen of the jury, as you know, the criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberations. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick, and juror number...
Whoa, they did that just in time. You know, I think she's got really pretty hair. It's nice and long. It's natural. I think she's red bone. She might be originally from Louisiana. Man, she should have taken that plea deal.
May the record reflect we are outside the presence of our jury. Do you guys have any further matters?
Well, that's it. I'm not going to stay live for a verdict. When they say they have a verdict, I'll come back and do it live because I'm exhausted. It's been a long day. I've been up since 4:00 this morning and I haven't had no nap, no sleepy time for Ronnie. So I will come back once there's a verdict. I mean, if I could keep it running and not have to say anything, I would. But I don't want to get in trouble. I don't want to get tossed out by TOS, TOS, terms of service. But anyways, thank you so much for being here today. I truly appreciate it. And if you're in the replay, please remember to like, share, and subscribe. And let us know in the comments what you think. You think Devyn is guilty, or do you think there's someone else involved? All right. Well, until there's a verdict, I won't be back until tomorrow at 9 a.m. Unless there's a police chase or something, then I'll come back live for that. But I don't know how long they're going to keep the jury for. I suppose a couple of hours. What do you think, Kathy? You think they'll keep the jury for a couple of hours? I just don't want to miss the verdict. I didn't think I didn't think you were here. Kathy, you still here? Hello? Sandy? Sandy, are you here? All right, well, oh, someone's calling. Hello? Hello? Oh, this stupid phone. Hello? Yeah, hi. I'm just finishing up my live. Oh, I probably shouldn't. Where are you guys at? I'm here, Kathy. I love you. Well, you can look on the camera. Can you see me on the camera? No, the camera in my bedroom. Yeah, you can look on the camera. You can even talk. Just turn on the yeah, you can even talk through the camera. Sorry, my boyfriend called, so they're going to Missouri, and they're at the Missouri Des Moines, right at the border, crossing over to Missouri. So, all right, well, I'll see you guys later whenever the verdict comes back. All right, bye bye. Have a good night. Stay safe.